I just want to make sure that everyone is on board. Okay, for some reason, some of our screens in the courtroom they are not cooperating. So, Mr. Parker, do you see your screen on?
It's spinning, waiting for host to start meeting.
Oh.
Jordan, Michael.
All right, I'm going to commence, and then we will take these little technical hiccups as we go along. Just waiting for everyone in courtroom 2 to be seated. Deputy Milton, how many people do you have in your room?
I have not gone and get them yet. I'm going to wait a little while.
All right.
And then I'll log back on.
Okay, no problem.
All right, thank you.
All right, courtroom 2, are we ready to proceed?
I'm ready. I'm gonna do all Mike McLean's clients first, Your Honor.
All right, I'm glad you got that organized. Thank you, sir. All right, good morning, ladies and gentlemen. My name is Judge Lal, and this is going to be the Fulton State all-purpose calendar. This is a calendar of misdemeanor criminal cases in which individuals have already had their initial appearance, most of them, and a bond has already been set in your cases. These cases have also already been accused by the Solicitor General's Office of Fulton County. Hence, today we're going to be addressing each of the cases to consider several options. One of those options would be whether the defendant, after conferring with his attorney or her attorney, has decided to take a plea. In other words, to enter a plea of guilty or no contest to some, if not all, the charges in exchange for a recommended sentence. In other cases, the defendant may choose to enter a plea of not guilty, and the case will then be a further notice for trial before the division judge or set for a bench trial. Other matters that I may address are bonds or any other issues that the attorneys would like to address at this time. Now, please, if you are a defendant accused of a misdemeanor offense, please remember your constitutional rights. These are meant to prevent you from incriminating yourself or making it more difficult for your attorney to represent you. First one's a right to remain silent. Anything you say about the facts of your case during the course of this recorded and live streamed court proceeding, your statements will be used against you in the treatment of your case. So please exercise your right to remain silent. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. So you should let your attorney speak on your behalf. Now, I'm going to be calling the first case, Mr. McLean. Looks like the deputy has specially arranged for you to address most of the cases first. So who do we have first, sir?
We're gonna go to position number 10, Mr. Lovelace.
Okay.
Lovelace.
You can have a seat over there, Schafferberg.
Darren Dion, Lavarionte Lovelace is accused of battery domestic violence from March 23rd, 2022. Ms. Lovelace, you've been advised of your right to remain silent. Your attorney presently is Mr. Mike McLean from the Public Defender's Office. And I understand that Mr. Lovelace would like to enter a plea of not guilty and have his case arraigned. Is that correct?
Correct, Your Honor.
All right. Do you waive a reading of the accusation, Mr. McLean?
We do.
All right. Mr. Lovelace, you have been accused of this battery misdemeanor family violence charge from March 23rd, 2022, allegedly in Fulton County, Georgia. Upon your entry of a not guilty plea, your case will be scheduled for trial. At the time of the trial, the state, the prosecutor, would have the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecution does prevail at the time of trial in carrying its burden of proof and overcoming your legal presumption of innocence, then you may be possibly convicted and face a penalty of up to a year in prison and or up to $1,000 fine. At the time of the trial, you will be represented by counsel and you will have the assistance in order to present any challenges or defenses you may have. Given this information, how do you plead at the present time? Mr. Lovelace, how do you plead at the present time?
Signature.
I'm sorry, I can't hear you.
Signature.
Mr. Lovelace, please repeat your response, and I hope it's not a profanity.
A real signature.
All right, Mr. McLean, I do not understand your client. Has you conferred with him?
I have. Sometimes he is difficult to understand. His speech is sometimes slow and at times occasionally unintelligible.
All right. Mr. Lovelace, would you like a trial in your case?
You gotta say so.
Yes.
All right. I'm going to
There-
construe that as a not guilty plea. The case has been arraigned and further notice for trial. Mr. McLean, I understand you also want to address bond. What is your argument, sir?
Your Honor, he does have community ties. He's from here. I realize it's a family violence case. He has other relatives and would ask that the $5,000 cash bond that I believe is currently on there be substantially reduced if possible.
All right. I'm sorry, who's prosecuting this case? Is it Ms. Duncan?
Yes, Your Honor. Good morning.
Good morning, Ms. Duncan.
The state would object to a bond reduction given that there has been no material change in the facts and circumstances surrounding this case. In this case, the defendant punched his 66-year-old grandmother in the face, leaving visible markings, cuts, swelling, and bruising. When officers arrived, her eye was actually bleeding. He fled the scene on foot, and Your Honor, this dispute arose because his grandmother would not give him 50 cents. In addition, Your Honor, this defendant has other violent charges. This defendant pled guilty under first offender to simple battery, and terroristic threats in 17 SC 151199, as well as felony aggravated assault and possession of a knife in 17 SC 152707. Also, I would like to note for the record, the state has a concern about this particular witness and intimidation and risk of reoffense because on March 27th, 2020, this same victim filed for a protective order under 2020 CV 334088. But that protective order did become dismissed because the victim did not show up, but we're concerned about the health and safety as well as the security of this victim along with the other factors listed. And for those reasons, the state will request that the bond not be reduced at this time.
All right. 312, if I may. 312 here, Ms. Harrison.
Yes,
Harrison,
Jen.
good morning.
Good morning.
Is Mr. Lovelace still on probation with regards to his prior cases?
No, it appears it expired, but it
Oh.
doesn't indicate if it was sealed, just that it was
Okay.
first offenders.
All right, thank you. All right, Mr. McLean, do you have a response?
Your Honor, I did mention that there were community ties other than the alleged victim. I believe it is an uncle of his that he would be able to stay with if he were able to get out of custody.
All right. And what's the name of this uncle?
I'm searching for those papers. Was that
Position
Mr.
10,
Lovelace,
Mr.
was it-
Lovelace?
Mr. Lovelace? Was that your uncle Randy that I'm thinking of?
Yes.
Okay, that is Randy Lovelace, I believe his last name is.
Yes.
Randy Lovelace is your uncle?
Yes.
Right. And I can Google that address. He's got the street, but not the street number. And I can find Mr. Lovelace. Unfortunately, because of interviewing yesterday, I have not found him yet,
Okay.
but right.
I would need Mr. Randy Lovelace's address and contact information. I would also need verification from Mr. Randy Lovelace that Lava Rionte is going to be living with him and staying 500 yards away from the victim in question.
Right.
No drugs, no alcohol, no weapons. Bond is amended to a $5,000 surety bond. It would need to have a co-signer. I am requiring a co-signer not because of Mr. Lovelace's age, but because of his apparent non-responsiveness. I am a little concerned about his ability to communicate and understand the proceedings. So I am going to require Mr. Randy Lovelace to co-sign the bond. He would need to provide a government issue ID and a utility bill or whatever we require to show that he's living at the premises that he claims to live at. Understood?
Very good.
All right. And this is right now a surety bond. All the previous conditions remain the same. This case is arraigned and further notice for trial. Thank you.
Thank you, Your Honor.
Thank you.
Deposition number 15, Mr. Trappenberg.
Daniel John Trappenberg is accused of theft by shoplifting and simple battery. And this is from a March 23rd, 2022 incident. Mr. Trappenberg, you've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. I understand this is to be arraigned as well.
Correct.
And Mr. Trappenberg, do you waive a reading of the accusation, Mr. McLean?
We do.
All right. Mr. Trappenberg, you've been accused of these two misdemeanor offenses, including simple battery, which allegedly occurred on March 23rd of this year in Fulton County, Georgia. Upon your entry of a not guilty plea, your case will be scheduled for trial before the division judge unless you seek a bench trial. At the time of the trial, the prosecution, the Solicitor General's Office of Fulton County, has the complete burden to prove the charges against you beyond a reasonable doubt. If the state succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Your Honor, I plead not guilty, and I would like to have it as a court record that I was assaulted by an officer here. I was not allowed to ever make a phone call to my attorney. In 14 days I've been here, I've been beaten, sodomized, and not allowed to call my doctor or my attorney.
So noted. Mr. McLean, I'm sure you'll make a visit as soon as possible to inquire about these allegations, correct?
Correct, Your Honor.
All right. This case, I accept your not guilty plea. The case is going to be arraigned. And I understand that you want to address bond as well, Mr. McLean. Please proceed.
Yes, Your Honor. As a practical matter, I cannot show substantial community ties. What I can show is that he currently has a $2,000 surety bond, and he does have some funds, but he can't get to them. Also, in the last 2 weeks, for some reason at the jail, he has not been able to contact his relatives and his usual attorney, or an attorney he has used in the past, I should put it, in Cleveland, Ohio. I now have that person's name since I just met Mr. Trappenberg yesterday, and I will find that attorney. Any practicing attorney is going to be fairly easy to find. And that attorney perhaps can help with getting the money, which Mr. Trappenberg does have, to apply to the bond. But as a practical matter, let's put it this way. He's going to need to make his bond practically as a cash bond. Proper surety companies, bonding companies in Georgia are going to require a Georgia co-signer. That's not going to happen. He doesn't have anybody in Georgia to sign for him. So as a practical matter, we would treat even a surety bond for him as a cash bond. That's the way he's going to have to do it. I would ask the court to consider lowering that to $500.
All right. Ms. Duncan?
Your Honor, the state would object to the bond being modified. There is no material change in the circumstances or facts surrounding this case. This defendant currently has 2 charges of theft by shoplifting and a simple battery, both with $1,000 surety. In this case, the defendant was in Home Depot at 2525 Piedmont Road.
Oh, I'm familiar with this case. So
yes, and The victim in that case actually did press charges as stated in the report. Given the facts and the violent nature of the offenses, the state will request that the bond remain the same.
All right. Mr. McLean and Mr. Trappenberg, I was the judicial officer who initially addressed this case, and I'm the one who set the bond. Presently, I don't see a change in circumstances.
May I speak?
Not yet. So under the circumstances, I find a very little cause to amend the bond as it's presently set. Now, with regards to the allegations brought by Mr. Trappenberg, Mr. McLean, I am sure your office is going to go there and address the claims and see what's the next step to take with regards to Mr. Trappenberg's allegations. Now, Mr. Trappenberg, if you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you in the treatment of your case. And unfortunately, this entire proceedings are being recorded as well as live streamed. So I would highly recommend that you let your attorney speak on your behalf.
Well, I understand my rights, and I would like to say that due to the incompetence of this prison system, if I'm not allowed access to my cell phone and my personal belongings, I don't have a chance in hell of contacting my lawyer, nor will they allow me to because I'm complaining about them doing wrong. So I would like to talk to a federal agent. I was also told that my car, I had $100,000 worth of crap stolen from me. My car, stuff in my hotel, they threw out all the stuff in my hotel. This is ridiculous. For $200 misdemeanor, I've been sodomized, and you are going to keep me here, and I'll probably get murdered. So you are sentencing me to a death sentence. Thank you very much. By not giving me a signature loan and allowing me to get access to my stuff to
Deputy,
talk to
we
my
are
lawyer.
concluded with this case. Thank you.
Okay, Your Honor, thank you. Come on.
Just let me know when you're ready to address the next case.
And Your Honor.
Yes, Mr. Finley.
Good morning, Judge. When court began, I was on the phone with a couple of my clients, and I just want to let you know I'm now ready to proceed with any.
Okay, all right. I think the deputy has arranged it so that we address Mr. McLean, so
Okay.
I'm going to let them do the rotation, okay?
Understood. Thank you,
Mr.
Judge.
Finley, I'm sorry, I have one more person that you need to speak with, and he's coming down now. So I'm gonna keep
Okay.
going with Mr. McLean's client. Judge, I have
Okay.
position number 1, please.
Perfect. Thank you.
You welcome.
Position number 1, that's Mr. Finley.
Add on position number 1.
Oh, add-on position. That's Mr. Finley as well.
Okay.
That's mine as well. That is a negotiated.
Okay, position add-on is, are you ready to take that? Okay.
I'm
We
ready,
have
Judge.
Tanelius Lovett, accused of theft by shoplifting in case number 20 CR 000-166A. Mr. Lovett, you've been advised of your right to remain silent, and your attorney is going to be Mr. Zach Finley. Understand this is going to be a negotiated plea. So, Mr. Lovett, for purposes of the plea, may I place you under oath?
Yeah.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Thank you. Miss Duncan, is it?
Yes, Your Honor, this
All
is
right.
my case.
All right, Miss Duncan, are you the only ASG this morning?
No, there's ASG Webb as well, and
All right.
ASG Walker.
We're here,
Okay.
Judge.
All right, just want to be sure. Thank you. All right, Miss Duncan, what is the plea offer?
Yes, Your Honor, for the charge of theft by shoplifting, the state is recommending 12 months to serve, 88 days, credit for time served, 88 days with the balance suspended, and a stay away from the sit-go at 1362 Boulevard Southeast in Atlanta.
All right, thank you. Mr. Finley, anything else to add?
No, Your Honor. Just that we do agree to the state's recommendation and additionally stipulate to the factual basis, ID, and venue.
Thank you, sir. Mr. Lovett, presently, have you consumed any prescription medication or drunk any alcoholic beverages recently?
Oh, man.
And have you understood the proceedings so far?
Oh, man.
Repeat, please.
Yes, ma'am.
Okay. And are you satisfied with the explanations and the representation you received from counsel?
Yes, ma'am.
And is anyone forcing you to take a plea this morning?
No.
If you decide to plead guilty to the charge of theft by shoplifting, you would have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury, to be able to have the assistance of counsel to challenge the state's case, present your own defenses, examine witnesses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? And Mr. Lovett, if you plead guilty to this theft by shoplifting charge, this will be a conviction of your record. And if you accrue 3 or more theft by shoplifting convictions on your record, any future arrest for theft by shoplifting will automatically be a felony. Did you know that?
Yes, ma'am.
All right. So are you still prepared to go forward with this plea?
Yes, ma'am.
And are you doing so willingly, voluntarily, and knowingly?
Yeah.
How do you plead to the 1 count of theft by shoplifting?
Yeah.
Your sentence is time served. This case, your time on this particular case is concluded. If you have no other holds at the Fulton County Jail or any other jurisdiction, you should be released within 24 hours. If you return to the Citco gas station at 1362 Boulevard, you will be arrested again. And guess what? We get to do this all over again. All right? So please stay away from the Citco gas station. Understood?
Amen.
All right, sir. Thank you.
Position number 6 is next, please, Judge.
Position number 6, we're still keeping Mr. Finley there?
And that's a
I'm doing it for a particular reason, Judge. I do apologize. I'm sorry.
That's okay. That's okay.
Thank you.
That's okay. I wasn't sure. Okay. Position number 6, we have Demarcus Dewberry, and Mr. Dewberry's case number is 22 CR 001-683J, in which he's been accused of simple battery from March 17, 2022. Mr. Dewberry, you've been advised of your right to remain silent, and your attorney is Zach Findling. This, I understand, is going to be a negotiated plea. Is that correct?
That's correct, Judge.
All right. Yes, Miss. It is a negotiated plea. So for purposes of the plea, Mr. Dewberry, may I place you under oath? Mr. Dewberry?
I'm on oath. My hand raised right now. I'm listening to you.
Raise a little higher, Dewberry.
I just need to see it. Thank you. Do you solemnly swear and affirm the testimony you provide will be the truth?
Yes.
All right, you can put it down. Thank you. All right, Miss Duncan? Oh, Miss Webb?
My case, Your Honor.
All right, Miss Webb. All right, thank you. And what is the state's recommendation, please?
Yes, Your Honor. The state is recommending 12 months to serve 76 days, credit for time served 38 days with the balance suspended. No further contact with James Spencer, that's James common spelling, Spencer common spelling, and no further violent contact with the Rice Street Jail personnel. Nothing further, Your Honor.
Thank you. Mr. Finling, do you agree to those terms and stipulate to factual basis venue and ID?
I do, Judge.
All right, thank you. Mr. Dewberry, have you consumed any medication or alcoholic beverages recently?
No.
And have you understood the proceedings so far?
You know what y'all say? Somebody, how many days, sir?
The time left to serve on this particular case involving a simple battery that apparently occurred at the jail on March 17, 2022, your time for this case is served if you accept the plea. I don't know about your other cases. All right, so given this explanation, have you understood everything else so far?
I got stabbed, but y'all love me for it, but you said time served, so it is what it is.
All right, Mr. Dewberry, you've been accused of simple battery due to an incident at the jail on March 17, 2022. If you want to move forward and willingly, knowingly, and voluntarily plead guilty to this charge and waive your constitutional rights to go back to court to challenge this charge, then I can accept your plea. But I cannot accept your plea if you want to challenge this charge.
I ain't challenging the charge. I said I'm guilty to whatever it is, whatever y'all
All right.
going on.
So listen to my question. Listen to my questions. And if you don't understand my question, then go ahead and say I don't understand. Understood? Do you understand?
I just said I plead guilty.
Mr. Dewberry,
What's up?
please, sir, in your best interest, if you could wait for the judge to finish and then respond yes or no, please. Please, sir.
Have you understood the proceedings so far?
Yeah,
Have you understood your attorney, Mr. Finley, when he explained the terms of the plea offer?
yes,
Are you satisfied with the representation of your attorney?
yeah,
If you decide to plead guilty to this charge, you will have to give up your right to go back to court, to have a trial in this case, to challenge the state's evidence, to present your own defenses, to be able to have the assistance of counsel, to argue your case before a judge or a jury, to examine witnesses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. These are your constitutional rights that you have if you decide to challenge this charge in a court of law. Are you prepared to give up these rights and enter a plea?
yes,
Is anyone forcing you to take a plea today?
no,
How do you plead to one count of simple battery?
yes,
I accept your guilty plea. Your sentence is time served. Your time on this particular case is concluded, and you are to have no further violent contact with any of the personnel at the Wright Street facility. If Mr. James Spencer is still housed at the Wright Street facility, then the sheriff of Fulton County will have to make sure that you are housed separately from him because you have to have no further contact with him. Understood?
yeah.
All right, thank you.
Judge, if we can go to position number 12, Mr. Malinsky, I don't know if I'm pronouncing that right.
That's fine.
That's right.
And Amid Melis,
Yes,
Yes.
Judge.
Your Honor, if I may, the state would like to proceed with this case in a breakout room.
all right.
Um,
And who's representing Mr. Melis?
I do, Your Honor.
Mr. McLean? Okay.
Sir.
Will the host please place Ms. Duncan, myself, Mr. McLean, and Mr. Walker in a breakout room, please?
Mr. Jackson, you need to talk to your attorney.
Mr. Walker, who's your client?
Huntley, Your Honor, Kenia Huntley.
Huntley? All right. Position 8, okay. And courtroom 2, the next case, if we could take Mr. Huntley. Do you have Mr. Huntley in the courtroom? Courtroom 2?
What's the last name again, Judge? I'm sorry, please.
Position 8, Huntley.
I think South Annex made an
Was
inquiry
she
about
No,
that.
this is a female. She's at South.
female? Okay,
Female.
all right, thank you.
End.
Judge-
Unfortunately, we have to wait till we finish courtroom 2, then we'll go
That's
to the
fine, Your
next
Honor.
facility. Her counsel's in
Judge-
the courtroom. So
Judge, who else did you need the breakout room for?
just for position number, what
Was it Duncan, Walker, you, and McLean?
It was for myself, McLean, Duncan, and Mr. Walker, yes.
Thank you.
All right, courtroom 2. All right, we're going to place Mr. Malise on hold because Mr. McLean would need to call the jail to discuss a possible plea offer.
Yes, Judge, thank you. Mr. Amelie, go have a seat. We're gonna come back to you, okay?
And Mr. McLean, you have the jail's number. It's 404-612-2392.
Mr. McLean, I have Mr. Finley on the phone call with one of his clients, so if you could just give me one moment, please.
Oh, we'll take the next case for Mr. McLean, please. He'll call as soon as he's done. Do we have a Vietnamese interpreter on?
This is gonna be the next person I call, Judge, position number 13.
Okay.
She's gonna be logging in a few minutes, Judge.
Okay, let's hold on position 13. Our interpreter still needs to log in.
Your Honor, there's private counsel on the Zoom as well. For position 14.
14.
We can go to court, Judge.
Is Charles Pearson in the courtroom?
Yes, he can be next, Judge. Thank you.
All right. And Ms. Watson? Mr. Watson?
Mr. Watson. Hey, Judge.
Mr. Watson, good morning, sir. Good morning.
How are you?
Fine, thank you. Fine, thank you.
Good.
All
Good.
right, we have your client, Charles Drew Pearson, 20 CR 02915, excuse me, 0029158. And Mr. Pearson's got a DUI charge, let's say, from a September 24th, 2019 incident.
Yes, Judge.
Mr. Pearson's been advised of his right to remain silent, and his counsel is Mr. Watson. Sir, how is your client proceeding in the case today? Are we arraigning the case or taking a plea or anything else?
Judge, this will be a plea today. I've advised my client of the state's recommendation of 12 months to serve, 24 hours credit for time served, balance probated, a $600 fine, 40 hours of community service, risk reduction program, alcohol, drug evaluation and treatment, and the victim impact panel. That's correct, Ms. Duncan, right?
Yes, that is correct. 12 months to serve, 24 hours credit for time served, 24 hours with the balance probated, $600 fine, 40 hours community service, risk reduction, ADET, and victim impact panel.
All right, thank you. Mr. Pearson, if your client decides to proceed with the plea, do you stipulate to the factual basis, venue, and ID?
Yes, Judge.
Thank you. Mr. Pearson, if you please raise your right hand for purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. So, Mr. Pearson, you've already conferred with your attorney and understand that you would like to enter a plea with regards to this charge. First of all, have you consumed any kind of medication or alcohol recently? Have you consumed any medication, drugs, or alcohol recently?
Oh, no, ma'am.
And have you understood the proceedings so far?
Yes, I do.
And are you satisfied with the representation that you've received from your counsel?
Yes, I am.
And also, is anyone forcing you or inducing you to take a plea today?
No, ma'am.
If you decide to take a plea, enter a plea of guilty to this charge today, you would have to give up your constitutional rights to challenge this charge in a court of law. Specifically, you would have to give up your right to a trial before a judge or a jury, to have the assistance of counsel to go back to court, to challenge the state's evidence, present your defenses, confront your accuser, examine and cross-examine witnesses, argue your case before a judge or a jury, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
And do you understand that by taking this plea, this could have an impact upon any open cases or your residency if such things are applicable to you?
Yes, I do.
And are you taking this plea freely, willingly, and voluntarily?
Yes, I am.
And how do you plead to the one count of DUI under the influence of alcohol, less safe?
Guilty.
All right, your sentence is 12 months to serve 24 hours, credit for time served 24 hours. The remainder of the time you'll be on probation. You will report to probation. Do we have a good address on Mr. Pearson?
I do not, Judge, but if Mr. Pearson, if you could provide the court with a good address for you, a good current home address.
Okay,
Yeah.
hang on. Before he announces it in open court, I have a Wedgewood Drive in Fayetteville. Is that still a current address?
Yes, ma'am.
All
Yeah.
right.
Okay.
Probation will contact you at that address and send you a date and time to report to probation. You must report to probation. While you're on probation, you will pay a $600 fine. You will complete 40 hours of voluntary community service. The community service must be completed at any nonprofit agency except a school or religious institution. Do you understand, sir?
Yes, ma'am.
You will also complete one risk reduction program, submit yourself to an alcohol and drug evaluation, and if the provider says that treatment is required, you will submit yourself to that treatment. You're also to attend one victim impact panel. All these conditions must be completed for the remainder of time that you are on probation. You will report to probation every month. Anything else, Mr. Watson?
Judge, I would just ask that, assuming Mr. Pearson is able to timely complete the conditions of probation, that his probation become non-reporting.
Any objection, Ms. Duncan?
No objection, Your Honor.
All right. If he completes all the terms of his probation and probation satisfied, then he.
Judge, I'm sorry. Judge, give me one moment. I do apologize.
No problem. While we're waiting, I do see that JCS probation is present, and probation, am I correct? You will send notice to Mr. Pearson's address to show up at a particular date and time?
If he had a number, a phone number, contact number, then that would be best, because unless you put him on non-reporting, that he don't have to come in.
He has a home number, a cell number, and an email on the Odyssey. Are you able to access that?
I can get it from my manager.
Okay.
Well, Judge, let me just point out, and maybe it's just I don't have enough of a winning personality, but I've emailed Mr. Pearson and I've called him at the one good contact number I had for him, and I've never received a response.
Okay, you've never received a response?
No, ma'am. Well, let me back up. I haven't received a response in months with respect to the email address or the phone number. Okay. So it may be a good idea for him to give a new number.
Thank you, Mr. Watson. Mr. Pearson, we have a deputy in the courtroom. Could you give your current phone number and current email to the deputy, and we'll put that in the chat to JCS probation, please?
Your Honor, I have a brand new cell phone, so I don't memorize that number yet.
And what's your email?
TrueArt61@yahoo.com. That used to be my old one, but I think it done changed since then.
What's your new email? Spell it out slowly.
I can't remember it.
Your email as well?
Oh, yeah, yes.
All right.
I can tell you my old email address.
All right. In that case, probation, I'm going to give him a date and time to respond. He's going, Mr. Pearson, once you are released from jail, you will report to probation either next Monday, but no later than next Tuesday. Understood?
Yes.
So that would be April 11th, no later than April 12th. And probation's office is at 132 Mitchell Street in Atlanta, Georgia.
Will they give me that address on paper?
Mr. Watson, we've got it written down, and you need to contact your attorney. Do you see him on the screen?
Yes, ma'am.
All right, you need to contact him just to get that information.
Okay.
Mr. Watson is 132 Mitchell Street in Atlanta, Georgia. They haven't moved for as long as I can remember. So maybe they're ready for a new crib, but right now I'm pretty just stuck there.
No, ma'am, we're stuck.
Understood. Understood, Judge.
All right, Mr. Pearson, best of luck. Thank you.
Thank you very much. Thank you very much.
Judge, that's the only case I have. May I be excused?
Yes, sir. Have a good morning, Mr. Watson.
Hey, you
Take
too,
care.
Judge. Thank you.
Judge, thank you for that. I do apologize.
No problem at all. Do we have Mr. Nguyen, please? Mr. Nguyen,
Yes.
position 13, please.
And Judge Law, just, I'm back and I'm ready for any of my clients that may be called.
Excellent. Okay. I believe Mr. McLean is representing Mr. Nguyen.
That's correct.
All right. Good morning, Miss Wendy. How are you?
I'm fine.
Oh, thank you, Mr. Nguyen. How are you, sir?
I'm fine. Yeah. I'm fine.
Good. Okay. We have a Vietnamese translator, and if you could please unmute your phone.
Yeah.
Can I also get the spelling of Miss Wendy's last name, please?
Yeah. As soon as she unmutes, I'll get that.
Thank you.
All right. Good morning,
Good
Miss
morning,
Wendy.
Judge.
Miss Wendy, could we have your full name, please?
WYNDI. Last name is PHAM.
Miss Pham?
Yes, ma'am.
All right. Miss Pham, if I may place you under oath, please. Do you solemnly swear and affirm that the Vietnamese translation you provide will be a true and accurate translation with no changes or embellishments?
I do.
Thank you. If you could please address Mr. Ngoc Van Nguyen. He's in courtroom 2. If you can see him on the screen, let him know that this is going to be, we are addressing his criminal case.
Hello anh Nguyễn, anh Ngọc Nguyễn. Bữa nay là cái ngày xử cái tội trạng của anh nha.
Yeah. Cảm ơn chị.
Yes, thank you.
All right. And please advise him that whatever I say or the attorney say, that you will translate it to him.
Yeah.
Những cái gì mà cô tòa hoặc là luật sư của anh nói chuyện với anh đó thì mình sẽ thông dịch lại cho anh, okay?
Yeah.
Yes.
Mr. Ngoc Van Nguyen, case number 21 CR 007648F.
Hello anh Ngọc Nguyễn, cái case cái số của anh là 21 CR007648F.
He is accused and charged with criminal trespass and obstruction of an officer from December 7th, 2021.
Anh bị kết tội là anh đi tới cái vùng đất của người ta không có sự đồng ý của họ và anh đã cản trở sự làm việc của cảnh sát ngày 7 tháng 12 năm 2021.
Mr. Nguyen has a right to remain silent. Anything he says about the facts of his case, his statements can and will be used against him.
Anh có quyền không có nói gì hết. Những cái gì mà anh nói có thể dùng để mà xử cái tội về cái tội của anh nha.
He has a right to an attorney and his attorney's name is Michael McLean.
Anh có quyền lợi là anh có quyền mướn luật sư và luật sư của anh là ông Michael McLean.
Mr. McLean, what is your announcement for this case?
Your Honor, I did see him yesterday, and by coincidence, I met him about a month ago while he was in jail. I must have been helping out on an SAP or something then. What I'd like to do is convey the offer to him more explicitly. I talked to him yesterday. I'm not sure that he understood everything I was saying. I know he does have some English, but not a lot. So if we could go into a breakout room, I will make sure that he fully understands the proceedings and makes a choice.
All right. Miss Pham, I know that was a lot. Basically, please let Mr. Nguyen know that his attorney needs to speak to him over the phone. His attorney will be calling the jail. And Miss Pham, you may have to leave the Zoom in order to be part of a joint phone call with Mr. McLean and Mr. Nguyen.
Okay. Hello, anh Ngọc. Bây giờ luật sư của anh cần nói chuyện với anh nhá. Thì có thể là luật sư của anh sẽ gọi điện thoại vô trong tù để nói chuyện với anh.
Could you please ask Mr. Nguyen if he understood his attorney from the conversation they had yesterday?
Anh Ngọc, hồi hôm qua anh nói chuyện với luật sư của anh có hiểu hết tất cả những gì mà ông nói không?
Đừng nói anh là Lee, yeah. Yeah, nói tôi là ly nhiêu tiền, nó rất nhiêu tiền. Yeah.
Cái gì?
Ông nói tôi chịu tội hay không? Tôi làm những chuyện đó.
I think my attorney advised me to plead guilty for whatever that I did.
Okay, I think they need a conversation.
Right, I think
Deputy,
so.
Deputy, Mr. McLean was going to call courtroom 2 to speak to Mr. Nguyen. And Miss Pham, if you can put in the chat to Mike McLean, are you familiar on how to do that?
Excuse me, Judge, we can do a breakout session. You just have to give me 2 minutes so we can log on to courtroom 3. Then we can do a breakout session if that's okay.
That would be much easier. Thank you, Deputy.
Okay.
Thank you. All right, Mr. McLean, Miss Pham, please hold, and then we'll put you in a breakout once he's in a separate room. Thank you.
Excellent.
Thank you.
All right.
I'm sorry. Sorry to interrupt. For some reason, my video is not working right now. May I be allowed 1 minute to log off and log back in?
Oh, that's.
Or do you need me to be on video?
I mean, I'd love to have you on video, but it's not absolutely necessary.
Okay, I'm fine.
Okay, all right.
Thank you, Judge.
Thank you. Okay. Courtroom 2, I can take the next case with Mr. McLean while we are moving Mr. Nguyen.
Position number 11, Judge, Mr. Lyman, please.
Okay. I have Leotis Lyman, accused of battery, domestic violence, and criminal trespass from a January 23rd, 2022 incident. The accusation number is 22CR001708Y. Mr. Lyman, you've been advised of your right to remain silent, and your attorney is Mr. McLean. With regards to this particular case, I understand that you are planning to enter a not guilty plea and have the case further notice for trial. Is that correct, Mr. McLean?
Yes, Your Honor.
Yes, Your Honor, and bond is not germane at this point.
All right. And do we waive a reading of the accusation?
We do.
All right. Mr. Lyman, with regards to this particular case, as I've mentioned, you are accused of the 2 misdemeanor criminal offenses. Upon your entry of a not guilty plea, the case will be scheduled for trial before the division judge. At the time of the trial, the prosecutor, the Fulton County Solicitor General's office, they have the complete burden to prove the charges against you beyond a reasonable doubt and to overcome your legal presumption of innocence. If the state succeeds, you could be convicted of 1 or more of these charges and face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Guilty, Your Honor.
Repeat.
Not guilty.
All right, thank you. Your case has been arraigned and it's going to be further notice for trial. Thank you.
Judge, Judge, we're going to position number 1.
All right, thank you. Mr. Finley? All right. And Mr. McLean and Ms. Pham, as soon as Mr. Wentz in the other courtroom, the host will place you in a breakout.
My apologies, Your Honor. Were we addressing bond on that previous case?
No.
No. We were not.
All right, with regards to position 1, we have case 22CR001860Y, State versus Fadli Bobel, accused of criminal trespass. Mr. Bobel, my name is Judge Lal, and you have been advised of your right to remain silent, and your attorney is Mr. Zach Finling. Mr. Finling, I understand that your client plans to enter a not guilty plea and move forward with the trial. Is that correct?
That's correct, Judge.
All right. Mr. Bobel, you have been accused of criminal trespass allegedly occurring on February 15th, 2022 in Fulton County, Georgia. With regards to this misdemeanor offense, you are represented by counsel, and upon your entry of a not guilty plea, your case will be scheduled for trial. Mr. Finling, do we waive a reading of the accusation?
I do, Judge.
All right. Once the case is scheduled for trial, the state would then have to be prepared and prove the charge against you beyond a reasonable doubt. If the state succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead? Mr. Bovell, how do you plead?
I think I should speak to my lawyer before I answer that.
All right.
Yeah.
Mr. Finley, would you like to call the jail and then see if he'd like to?
Yes, Judge.
Guess he needs to ask you a question.
Okay.
All right. Please have a seat and I'll take the next case from Mr. Finley.
Position number 2 is next, Judge, Mr. Brewer.
That's mine as well, Judge.
All right. Larry Brewer, State versus Brewer in case 22 CR 001794B. Mr. Brewer has been accused of criminal trespass and 1 count of public drunk. Mr. Brewer, you've been advised of your right to remain silent and your attorney is Zach Finling. Mr. Finling, what's the announcement?
Yes, Your Honor. This is going to be a negotiated plea, Judge.
All right. Mr. Brewer, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am, yes, ma'am.
Thank you. You may put your hand down. Thank you. Ms. Webb, what is the recommendation for Mr. Brewer's case?
Yes, Your Honor, the recommendation is 12 months to serve, 28 days, credit for time served, 14 days, charges to run concurrently, balance probated, alcohol, drug evaluation and treatment with a stay away from the MARTA at 5 Point Station located at 30 Alabama Street, Atlanta, Georgia. Nothing further.
All right. And do we have a good address for Mr. Brewer with regards to probation?
Yes, I do have an address, Judge.
All right. Phone number and email?
I don't have an email and he didn't have a phone number. I said for him to contact probation as soon as possible to have a phone number. He didn't have one of a friend, family memorized.
All right. The address we have on file at least is none. So if you can put his address in the chat feature, 1 to FC State Court and the other to JCS probation. All right.
Yes, Judge.
All right. And do you stipulate to the factual basis, venue and ID and anything else to add?
I do, Judge. I do stipulate. I would just ask that once Mr. Brewer does complete the ADET, if he could be, if the balance could be either suspended or not reporting.
When will he be able to complete the ADET?
And I told him if he can do that as soon as possible, as soon as he gets out.
So we have to read. All right. And Ms. Webb, before we do that, Ms. Harrison, any priors on Mr. Brewer?
Yes, Judge. 1 moment.
How many cycles?
48 cycles. I am on open probation, felony probation for burglary. He was sentenced.
I'm sorry, go ahead, Ms. Harrison.
Yes, he was sentenced in 2012 with 5 years confinement and 15 years probation.
Ms. Webb, I'm not inclined to do non-reporting. I will require him to report to probation every month, and he would need to complete the alcohol and drug evaluation within 4 months of being released. That should give him adequate time to at least get funding, and or if he can get a free evaluation, that would be great as well. And he'll need to submit himself to any treatment. If he completes his alcohol and drug evaluation within the first 4 months of probation, then all his probation fees are waived. Presently, the probation fees are only waived for the first 4 months, including the month of April. What that means, Mr. Brewer, is that within the next 4 months, while your probation fees are free, you need to complete an alcohol and drug evaluation with a qualified provider and submit yourself to any treatment that's required. If it's done within the first 4 months, then the rest of your probation fees shall be waived, but you must report to probation every month. You will be subject to random screens for alcohol, and you cannot afford to not report. You understand, sir?
I'm sorry, I didn't get an answer.
I didn't get an answer.
Yes, ma'am, I understand.
All right. And Mr. Finling, have you sent the address to JCS as well as to Fulton County State Court?
I sent it to JCS. I was about to ask what the other one was, but it's state court.
It's our host, Mr. Jordan.
Oh, FC state court. Got it. Okay, sending that one.
All right, got it. All right. So you stipulate to the factual basis, venue, and ID, and those are the terms of probation. Do you still want? I understand your client still wants to proceed? Is that okay, Mr. Finley?
Yes, it is, Judge.
All right. So, Mr. Brewer, you've been sworn to respond to my questions. First of all, have you consumed any kind of medication or alcohol recently?
Well, you know, ma'am, by the way, good morning. How you doing?
Doing fine.
That's good. Hey, on the medication I've been receiving is, you know, I got heart failure, and they ain't been giving me nothing in here for that. But
okay.
I used to go to Greater every week. You know, I would take it.
So once you're released, you're going to go back to Grady and get your medication?
Yes, I got some out there.
Okay.
Already, you know, my lace.
So my next question to you is that although you've not consumed any medication, have you so far understood the proceedings?
Yes, ma'am. I've been taking medication there. I have blood pressure pills and water pill, and you know,
okay, that's
I got
good.
the rest of the medication that I take.
Now, when you were talking with your attorney, have you understood what he's told you?
Well, you know, he said something. I understood what he said, but you know, he ain't said nothing about when you were talking about probation. You know, I already got 9 years or 8 months on probation.
Mr. Brewer, we spoke on the phone before court, and you discussed that you're on probation. I told you that your plea involved probation, sir.
If you don't want to plead guilty and you want to have a trial, we can still do that.
Yeah, I've been gone plead guilty.
All right.
So
and do you
when excuse me, man. When I start reporting the probation, like in May?
You will start probation next week.
And where is that located at?
132 Mitchell Street.
Yes, ma'am.
All right. So are you satisfied with the representation you received so far?
Yes, ma'am.
And Mr. Brewer, if you decide to plead guilty to public drunk and criminal trespass, you will have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to be able to challenge the state's evidence, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yeah, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
How do you plead to 1 count of public drunk and 1 count of criminal trespass?
Yeah.
I accept your guilty plea. Your sentence is 12 months to serve 28 days, credit for time served 14 days. If you have no other cases holding you at the jail, you will be released within 24 hours. This sentence will apply concurrently to both charges. Once you are released, you must report to probation by next Tuesday. Today is Thursday, tomorrow is Friday, then the weekend, and then next week. By next Tuesday, you must report to probation. Do you understand, sir?
Yeah,
I'm sorry, Judge. It's on. Could you make it on the Wednesdays, Monday, Wednesdays, and Fridays? I'm sorry.
Okay, sorry. Let me change that. You need to report by next Monday or no later than next Wednesday. So you report by next Wednesday. Would that be all right?
Yeah, ma'am.
All right. The location is at 132 Mitchell Street. Can you remember that?
I believe I can. Cross Street from the courthouse, huh?
Yep, that's correct. Got it?
Yeah, ma'am.
While you're on probation, you will complete one alcohol and drug evaluation by a qualified provider. Grady may offer that. And if they say you need to have some kind of treatment, then you must submit yourself to that treatment. Do you understand?
Yeah, ma'am.
This must be done within the next 4 months. So you have April, May, June, and July to complete this evaluation. If you complete it by the end, before the end of July, then all your probation fees will be waived, but you must report every month. Do you understand, sir?
Yeah, ma'am.
You're going to stay away from the MARTA 5 Points station as long as there is an active MARTA suspension against you.
Okay, can I ask you something, ma'am?
You sure may.
Hey, when did they give me a warning to stay away from model when I use model for my transportation to get back and forth to work?
I don't understand the question.
Mr. Brewer, it just states the 5 Point station.
Stay away from the 5 Point station.
Yes, sir.
That's correct.
So the other stations I can use to go back and forth to work.
As long as you don't break the law.
Yes, sir. Yes,
All
ma'am.
right. Thank you.
Thank you. You have a blessed day, ma'am.
You too. Thank you, sir.
Position number
You do the
5.
same, sir.
Thank you, sir.
Go over and sit down. Position number 5 is next, judge, please.
All right. Position number 5, we have Solomon Dennis, accused of loitering and prowling and misdemeanor obstruction from March 23rd, 2022 in Fulton County, Georgia. Mr. Dennis, you've been advised of your right to remain silent, and your attorney is going to be Mr. Zach Finley. Okay, I understand this is going to be a negotiated plea. Is that correct?
That's correct, Judge.
All right. Mr. Dennis, could you please raise your right hand for purposes of the plea? I need to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right, Ms. Webb, what
yes,
is
Your
the
Honor.
recommendation for Mr. Dennis?
Yes, Your Honor, the state is recommending 12 months to serve 30 days, credit for time served 15 days. The charges shall run concurrently with the balance probated, a stay away from 1985 Cannon Court, that's CANNON Court, College Park, Georgia, 20 hours of community service, Your Honor. Nothing further.
All right, thank you. Mr. Finling, do you have anything to add and do the necessary stipulations?
I do stipulate, Judge, and would just ask that probation fees be waived.
All right. And any objection to non-reporting once he completes the community service? Ms. Webb?
Your Honor, the state does not object so long as the defendant is aware to stay away from that incident location.
Okay. And Mr. Spindling, does your client have any other holds?
No, Your Honor. I do not see any holds, Judge.
All right, and I'm going to stipulate to factual basis venue and ID. All right, then I can continue.
Yeah.
All right, Mr. Dennis, first of all, have you consumed any kind of medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with the representation of your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you take this plea today to the 2 charges of loitering and prowling and obstruction of an officer, you will have to give up your rights to go back to court, to have a trial before a judge or a jury, have the assistance of counsel to challenge the state's case, present your defenses, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of loitering and prowling?
Guilty.
And how do you plead to 1 count of criminal trespass? Excuse me, misdemeanor obstruction of an officer.
Y'all can say, guilty.
All right, your sentence is going to be concurrent. In other words, it's going to apply to both the charges. And it's going to be 12 months to serve 30 days, credit for time served 15 days. That would conclude your time at the jail and you will be released to complete the rest of your sentence on probation. You will report to probation by next Wednesday at 132 Mitchell Street. And while you're on probation, you will complete 20 hours of voluntary community service at any nonprofit agency except a school or a religious institution. Do you understand?
Yes, ma'am.
I'm going to waive your probation fees for the first 2 months, including April and May. And if you complete your 20 hours of voluntary community service by then your probation will be converted to non-reporting. But if you've not completed the 20 hours, you will continue to report to probation and start paying probation fees from June 1st, 2022 onwards. Do you understand?
Yes, ma'am.
Non-reporting still means that you're on probation. So the entire time that you're on probation, you will stay away from 1985 Cannon Court in College Park, Georgia. Do you have any reason to return to that location?
No, ma'am.
All right, then you understand me. Thank you. That concludes this case.
Position number 10, Judge, Mr. Jackson, please.
Mr. Finling, I understand this is, you've already spoken to your, position number 10, you said?
Yes, Judge.
Is this Mr. Lovelace?
Number 9 is Jackson.
Oh, I'm sorry. I'm probably,
No problem. Just Mr. Finling, have you spoken to Mr. Lovelace?
Or Mr. Jackson?
No. Have you spoken to Mr. Lovelace? I believe I had him on hold with regards to a possible arraignment. He said he wanted to talk to you.
Oh, that was that was Mr. Ribali. Position 1 is the one I still have to talk to. And then Lovelace is not mine. That is
that's Mr. McLean. Okay, sorry.
Yeah, no, I was gonna call him, but I know we just did a couple of mine. So
okay. Sorry.
Jackson is position 9. That's who's in the chair, I believe, Your Honor.
All right, we have Darren Dion Jackson, 22 CR 001712E. And Mr. Jackson's represented by Mr. Zach Finling. And Mr. Jackson, you've been advised of your right to remain silent. He's accused of battery from September 2nd, 2020. Mr. Finling, what's your announcement for this case?
Yes, Your Honor. This is going to be a non-negotiated plea.
All right. So, Mr. Jackson, a non-negotiated plea means that the prosecution is going to first state their recommendation for a sentence in exchange for a plea, and then your attorney is going to state an alternative recommendation. I will consider both the recommendations and let you know which one I'm going to select, and then you can decide whether you want to move forward with the plea. Do you understand?
Yes, ma'am.
All right. You also have the option of pleading not guilty so that your case may be scheduled for a trial. So, Ms. Duncan, what's the state's recommendation?
The state's recommendation in this case, given the fact is 12 months to serve, 120 days, credit for time served, 14 days with the balance probated, 12 weeks of anger management, no further contact with the victim in this case, which is a Mr. Milton Reeves, and to stay away from the incident location, which is 1313 Sylvan Road Southwest.
All right. Mr. Finley? Oh, I'm sorry. Before we go, Ms. Duncan, did you want to state the
yes, the
prosecution's basis? Yeah.
The basis for this recommendation is the violent nature of this offense, and we're concerned about the safety of the victim in this case. Your Honor, in this case, on September 2nd, 2020, the defendant and the victim were engaged in an altercation, and officers were dispatched, and when they reached the scene, they spoke with Mr. Reeves. He advised officers that he was in an altercation with the defendant in this case while he was at the shop with his ex-girlfriend. And there was a physical altercation ensued where the defendant hit the victim in the face and hand with a crowbar, And in response and protection of himself, he grabbed a table saw and began to swing it to get the defendant off of him. And because he attempted to originally walk away, but the defendant followed him to his vehicle and began to continually assault him, and the assault escalated, and the defendant grabbed the crowbar. Like I said, Your Honor, given the violent nature of the offense here, we would request a bond as stated, and given the history in this case, given the defendant's criminal history is 16 cycles, has a probation revocation, and a conviction for simple battery from 2011, a possession of a firearm or knife during the commission or attempted commission of a felony from 2013, a probation revocation in 2018, a battery conviction from December 2019, as well as a battery arrest in 2005, and a aggravated assault with a deadly weapon from 2018, Your Honor. Given those facts, we're concerned about this defendant's risk of reoffending and the health and safety and concern of the victim in this case, Your Honor.
Is this a cross-defendant case? I don't recall.
The victim in this case was also arrested because of the severity of the nature of the weapons involved.
Okay. Mr. Finley?
Yes, Judge Law. First off, Mr. Jackson does strongly dispute some of the facts of what we heard. That being said, he does still want to move forward. We are asking for 60 days confinement as opposed to the 120 days. I'm sure that 120 days is heavily influenced by some of the facts that we just heard, but Mr. Jackson really made a point to say he was defending himself and disputes certain aspects of what we just heard. We would also ask for the 12 weeks of anger management to be 8-week anger management instead. Mr. Jackson does have a broken leg. He was working with a temp service previously called Top Notch and was getting odd jobs through them. He does have 4 kids who he supports. So like I said, Judge, would ask for the 60 days confinement and 8-week anger management.
Right. And with the 60 days, you would have 15 more days to serve at the jail?
Yes, Your Honor. It would be, I guess, 16 more days. Yeah, because he has 14 days as of today.
All right. So 16 more days at the jail. Considering that this was a cross-defendant matter, somewhat in which both parties, both the alleged victims and the alleged defendants in both cases, apparently were in combat with each other. Now, at this juncture, it's difficult to ascertain who was more culpable, but if Mr. Jackson would like to proceed with the plea, the recommendation of the court would be 12 months to serve 60 days, credit for time served 14 days, which means he has 16 more days to serve at the Fulton County Jail. He will be placed on probation to complete 12 weeks of anger management. Given his history of criminal record history of violence, I cannot in all good conscience reduce his classes of anger management, since clearly the more classes is perhaps of some benefit. Hopefully it doesn't result in negative returns. Also, he will be reporting to probation every month. He will have no further contact with Milton Reese. He's required to stay 200 yards away from Mr. Reese, not have any contact with him whatsoever, and stay 500 yards away from 1313 Sylvan Road in Southwest Atlanta. No illegal drugs, no weapons, no firearms, and no alcoholic beverages. He will be subject to random screens by probation every month for illegal drugs or alcohol. Mr. Jackson and Mr. Finling, would you like to proceed with this plea, or would you like me to arraign the case and have it scheduled for trial?
So just to make sure you understand, Mr. Jackson, previously it was going to be an additional 46 days in jail. But Your Honor, the judge is going to reduce that. So you only have 16 days, just to make sure that's clear to you, sir. Would you like to proceed with the guilty plea?
Yes.
I'm sorry, sir, we can't hear you.
Yes, sir.
All right. Mr. Jackson, in order to ascertain a plea, I have to make sure that it's freely and voluntarily being done. And you bowing your head and covering your face is not going to help matters. It's not. All right. I have a job to do. And if I feel that you are not being sincere in taking a plea and you're just taking a plea in order to get out of the jail, then I have the discretion to disregard the entire plea and schedule the case for trial. So I'm respectfully asking for your attention to this matter. I don't understand what you just said.
Right here.
Mr. Jackson, the decision is completely yours. I know I went over the different options. So if you do want to plead guilty, you just need to proceed and answer the judge's questions, sir.
Yes.
All right. Mr. Finling, do you stipulate to venue and ID in this case?
I do, Judge.
Thank you. Mr. Jackson, have you consumed any kind of medication or alcohol recently?
No.
Oh, I'm sorry. I need to place you under oath first. Sorry. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I just took my medicine on the way down here.
Okay. And does that medicine tend to make you groggy or impair your ability to understand?
No.
Okay. Your attorney has explained the procedure and the terms of a non-negotiated plea. Have you understood him so far?
Yes.
And are you satisfied with this representation?
Yes.
If you decide to go forward with this plea, you would have to give up your constitutional right to go back to court, to have the assistance of counsel to challenge the state's case against you. You will not be able to challenge the state's evidence, present your own defenses, confront your accuser, examine witnesses, as well as have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Is anyone forcing you to take a plea today?
No.
Are you taking this plea freely, willingly, and voluntarily?
Yes.
How do you plead to the one count of battery with regards to a September 2nd, 2020 incident?
Guilty.
Your sentence is 12 months to serve 60 days, credit for time served 14 days. You have 16 actual more days to serve at the jail. Once you have completed the jail time, you'll be released. Then you must report to probation within 7 days of being released. You can report on I believe probation has clarified, you can report on a Monday, a Tuesday, or a Thursday, but it must be done within 7 days of being released. Do you understand, sir?
Yes.
Repeat that.
So yes.
I understood. Just 1 second. I'm sorry. Oh, no. She's corrected that in the chat. Okay. So you will report to probation and once you've reported to probation, you will complete 12 weeks of anger management classes at your expense. Those classes must be commenced within 30 days of being released. So by the time you report to your probation on the second visit, you must show proof that you have started your anger management classes. Your probation fees shall be waived for the first 6 months of your release. And then after that, you will start paying probation fees, but you will continue to report to probation. You will be subject to random screens for illegal drug and alcohol. So therefore, while you're on probation, no illegal drug consumption and no alcohol consumption. At all times, you're not to possess any weapons or any firearms. That concludes your plea. Do you have any questions about your sentence?
No.
Thank you. All right, thank you, sir. That concludes your case.
Position number 7 is next, Judge.
All right. Mr. Jordan, is Mr. McLean concluded with his conference with our interpreter?
He's still in the breakout room, Judge.
All right, please let him know that we are ready for him anytime soon. Okay. All right, and I beg your pardon, what position number is this again?
Position 7.
7. Oh. I have Keenan George Drake, case number 22 CR 001715B. Mr. Drake is accused of theft by taking from a September 1st, 2021 incident. And Mr. Drake, you've been advised of your right to remain silent, and your attorney is Zach Finley. Ms. Webb, what is the status of a transfer?
Your Honor, the defendant actually has 2 open cases in Fulton County. One case that is being prosecuted by our office, which is the case that's on today's docket. He also has another case that occurred 3 months ago, 3 months after this incident date with similar facts, and that case is being prosecuted by the DA's office, Your Honor. So this case will remain as a misdemeanor.
I see. All right. And Mr. Finley, what is the announcement?
Yes, Judge. This will be a just an arraignment, jail jury. Yeah,
Okay. All right. And do you waive a reading of the accusation?
I do.
Thank you. Mr. Drake, you've been accused of 1 count of theft by taking with an alleged incident date of September 1st, 2021 in Fulton County, Georgia. You are represented by counsel, and with regards to this misdemeanor offense, if you decide to plead not guilty, your case will be scheduled for trial. At the time of the trial, the state has the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right, sir, your case has been arraigned and further notice for trial. This concludes this case. Thank you. Oops.
So I have 2 defendants in the courtroom that need to speak to Mr. Finley. I'm sorry, 1.
Yeah.
Yeah, I'm sorry.
All right. And who's the other one?
And then there was one more who was going back to position number 12, Mr. Melise.
And he is Mr. McLean's client, and Mr. McLean is still in the breakout. So, Mr. Jordan, if you could let Mr. McLean know that we are now ready for him, and I'm going to take up South Annex while he wraps it up with his breakout. Thank you. South Annex, do we have Ms. Huntley, please?
Ms. Huntley?
Council, if, okay.
Position 8.
8, yeah. All right, Miss, how do you pronounce your client's first name?
Kanaya.
Kanaya. Kanaya. Okay. Miss Kanaya Rochelle Huntley, case number 22 CR 001795G. Miss Huntley is accused of criminal trespass and battery. Miss Huntley, you have a right to remain silent about the facts of your case. Any comments you make, your statements can and will be used against you. Your attorney, Mr. Parker, is in the courtroom. And Mr. Parker, if you don't, oh, you're already ready with your file out there, so that's fine. Can you see your attorney on the screen? Mr. Parker, if you could raise your hand, please. Can you see him?
Yes.
All right. Are you comfortable with him being seated there, or would you like him closer at the podium?
Whatever he's comfortable with. He's already moving.
You good? You good? Okay, he's come forward to the podium. Do you see him on the screen?
Yes, I do. Yes, ma'am.
He's a really tall guy. He's about twice my height. So,
I see him.
literally, I think he's twice my
He's
height.
very noticeable with his sharp suit. I see him.
There you go. Okay.
Can I
All
please
right.
get Mr. Parker's first name?
Oh, Alan.
Thank you.
All right. Mr. Parker, prosecutor for this case is Miss Webb. Do you see her on the screen, sir? Okay. All right. And Mr. Parker, what is your announcement for the case? Are we arraigning, taking a plea? Or? Okay. All right. And would you like to address bond as well?
Yes, my understanding that on the day of the hearing that she was granted
I'm sorry, Judge. It's very hard to hear him. I don't know if there's a microphone he can get closer to, but I can't understand him.
There is a challenge. The microphone is vertically challenged. So, okay. Sorry, Mr. Parker. Oh, he knows how to do that. Okay.
Can you hear me now, Counsel?
No.
Court reporter, can you hear him?
No, Judge, I'm sorry.
Just can someone check to see if that microphone is turned on? I think someone may have turned it on. It's on the top. There's an off and on button on the top of it.
Yeah, it's in the up position. That should be on, correct?
Is that better?
We still can't hear him.
Yeah.
Counsel, I think the microphone at the desk works. All right, Mr. Parker, is that better?
Can you hear me now?
Perfect. Thank you.
Yes.
Just go with that one.
Okay.
All right, thank you. All right, so yes, she did have an initial appearance, and at that time she was granted a bond, and the bond order was for a $2,000 surety bond with no further contact with Alfonso Thomas and Karen Thomas, and to stay away from the Brewer Drive location, no weapons, drugs, and alcohol. So if you'd like to address bond, we'll first arraign the case. And do you waive a reading of the accusation, Mr. Parker?
No, I don't, Your Honor. I just brought on last night.
Certainly. The accusation was filed on March 29th, 2022. All right. So, Ms. Huntley, your attorney, as I've said, is Mr. Parker, and we are going to arraign the case. That means you planning to enter a plea of not guilty, and the case will be further noticed for trial. With regards to your particular case, on March 29, 2022, the Fulton County Solicitor General, Keith Gamage, filed 2 accusations against you. The first one being accusing Kanaya Rochelle Huntley with the offense of criminal trespass, a misdemeanor, for that said accused in Fulton County, Georgia, on or about July 1st, 2019, did intentionally damage a table, the property of Karen Thomas, without her consent, and the damage thereto was $500 or less by striking it in violation of Georgia law 16-7-21, contrary to the laws of the state of Georgia. With regards to your second accusation, filed the same day by the Solicitor General, Keith Gamage, does accuse Kanaya Rochelle Huntley with the offense of battery, a misdemeanor, but that said accused in Fulton County, Georgia, on or about July 1st, 2019, did intentionally cause redness and swelling, visible bodily harm to Karen Thomas by spraying her with pepper spray in violation of Georgia law, OCGA 16-5-23.1, contrary to the laws of the state of Georgia. With regards to both accusations, upon your entry of a not guilty plea to these 2 misdemeanor offenses, your case will be scheduled for trial before a judge or a jury. You will have the assistance of counsel during the course of that trial. And during the time of that trial, the prosecutor has the complete burden to prove the charges against you beyond a reasonable doubt. If the state does prevail, and you are convicted of one or more of these charges, you could be sentenced to up to a year in prison and or up to a $1,000 fine for each convicted offense. Given this information, how do you plead? Ms. Huntley?
Not guilty.
All right. There we go. This case has been arraigned. And Mr. Parker, as I said, your client presently has a $2,000 good bond. What would you like to state?
Your Honor, that the bond remained the same and we acknowledge all the conditions attached.
All right. Okay, so the bond shall remain the same. The case is further noticed for trial. Ms. Huntley, if you do make bond, please be sure to update us with any changes in your address, phone number, and email by contacting the clerk's office immediately. Do you understand?
Yes, ma'am.
And if you do make bond, you are aware that you have to stay away from Karen Thomas and stay away from the incident location. No illegal drugs, no alcohol, no weapons and firearms. Thank you. That concludes this case. Thank you.
Am I excused, Your Honor?
Yes, Mr. Parker, thank you for being so patient.
Thank you.
You have a great weekend. Thank you. All right. Proceeding to courtroom 3, we are going to address Mr. Nguyen. And can somebody remind me what position number was that? Position 13?
Position number 13.
Okay. And Mr. McLean, we also have to address your other client, Mr. Malise, shortly. Okay. All right, Mr. Nguyen, just to, Ms. Pham is here as well. Okay, Mr. Nguyen, I just want to remind you of your right to remain silent and that you counsel is going to speak on your behalf.
Ông Nguyễn à, bây giờ tôi cần nhắc nhở cho anh á, là anh không có cần phải nói gì nha, và luật sư của anh sẽ nói dùng cho anh nha.
Yeah. Mr. McLean, what is your announcement after your conference with your client?
Your Honor, I have some grave concerns about whether Mr. Nguyen can get through a plea. It may be possible.
So
he says he wants to plead guilty. I asked him, where did he get this notion about pleading guilty to whatever they charged you with? And he said somebody came to the jail and told him. I don't know. I have grave concerns about whether he would be capable of doing 20 hours community service. He has no memory of throwing any coffee at anyone. He has no memory of being told to leave a BP station. He does recall getting arrested, and it has to do with kicking a puddle of water that splashed.
I will deem this as a non-negotiated plea. So we'll hear from the prosecutor first, and then we will hear from the defense. Ms. Pham, could you please translate what I just said?
Bây giờ đó là cái hello anh Nguyễn. Bây giờ cái vụ án của anh á là không có thể nào mà điều đình được ha. Thì bây giờ đó là luật sư buộc tội đó sẽ nói chuyện trước, rồi sau đó sẽ nghe lời luật sư của anh sau ha.
Yeah.
Yes.
All right, Ms. Duncan, what's the state asking for in exchange for a guilty plea to these two charges?
For the first charge, Your Honor, for the obstruction, the state is recommending credit for time served 121 days with the balance probated in 20 hours of community service. And for the second charge of criminal trespass, the state is recommending credit for time served 121 days with the balance suspended and a stay away from the incident location, which is the BP station at 720 Donald Lee Hollowell. And that's it. Given the history of the defendant's criminal history, he has 2 convictions out of New York, 2 convictions with the Department of Homeland Security.
I'm going to pause right now. I'm sorry. Ms. Pham has to translate that.
Oh, my apologies, I forgot.
That's okay. Ms. Pham, yeah.
Bây giờ đó là luật sư buộc tội đó là muốn anh ở tù 120 ngày và 20 tiếng đi làm việc xã hội. Nhưng mà anh ở trong tù, cái số ngày anh ở trong tù sẽ trừ ra nha. Và thêm 120 ngày tạm tha. Và anh phải đi, anh không có được quyền tới cái cây xăng BP nữa.
Yeah.
Right. And as I was saying, the basis for this recommendation is the facts alleged, which is that the defendant was told to leave the BP station.
And he did not.
Và cái lý do mà người ta muốn anh làm như vậy đó là tại vì người ta đã nói anh là đi ra khỏi cái cây xăng BP mà anh không có chịu đi.
I'm sorry. I'm sorry. I was saying, and he did not leave?
No, he did not leave.
Okay.
Well, while leaving, he refused to leave at first, but then threw hot coffee towards the officer Sanchez while attempting to flee from arrest.
Anh lúc đầu là anh không có chịu rời khỏi cái chỗ cây xăng, và sau đó là anh vừa ném cà phê nóng vô người của cảnh sát và anh vừa bỏ chạy.
All right.
Your
Mr.
Honor,
McLean, yes, Mr. Walker.
I'm going to interrupt, and I apologize because I understand there's been some confusion with this case, and perhaps I'm going to make it even more confusing, but the state is going to take away the condition of probation and just let it be a suspended sentence, and just keep the stay away intact. That's probably the best thing to do with all that has occurred thus far.
All right, so the recommendation from the state now is time served and stay away from the incident location concurrent to both charges, correct?
Yes, ma'am. We'll leave it at that.
Mr. McLean?
Your Honor, it is my belief after questioning him that he does understand the idea of and is committed to the future behavior of staying away from that BP.
That's comforting. Thank you, Mr.
So
McLean.
that's something. Now, as to whether he understands any concepts that are remotely related to the concept of an offered plea, if he basically says that he wants to go home, he lives in a shelter, it's Gateway. He says he believes his income is still current. I encouraged him to seek a social worker's assistance in making sure that his disability check, if it is coming to an automatic.
Mr. McLean, you do understand that you have a translator who has to convey all that information.
Oh, right.
So, Ms. Pham, do you need Mr. McLean to repeat this?
No, ma'am.
Okay.
Hiện tại bây giờ đó là người ta yêu cầu là 120 ngày tù, nhưng mà anh đã ở trong đó 120 ngày rồi, và anh không có được quyền tới cây xăng BP nữa. Luật sư của anh nói đó là bây giờ hiện tại đó là anh nói là anh muốn nhận tội để anh đi về ở trong cái shelter của anh là Gateway Shelter đó, và luật sư của anh khuyên anh là nên kiếm người social worker để mà giúp anh lấy tiền, lấy được những cái check của chính phủ. Hiện tại bây giờ anh nói là cái tiền social của anh nó vẫn vô trong nhà băng của anh, thì không biết là có hay không, nhưng mà anh nói với luật sư là anh vẫn có tiền ở trong nhà băng.
All right. So, given that, does he understand that this will be convictions on his record? Go ahead.
Anh có biết là khi mà anh nhận tội này đó là trong cái hồ sơ của anh là anh có cái án như vậy không? Anh Ngọc.
Mr. McLean?
I believe he does understand that it is a conviction on his record if he pleads guilty. He understands the word guilty and that it adds to his, not just to his arrest record, but to the idea of a conviction.
Please translate.
Khi mà anh nhận tội ngày hôm nay đó là luật sư của anh nghĩ là anh hiểu là trong hồ sơ của anh sẽ có cái tội án này, và không phải chỉ là bị bắt thôi, nhưng mà anh có cái án này trong cái hồ sơ của anh có hiểu không?
All right. Well, Mr. McLean, I think I've heard enough to move forward with the plea with the state's amended recommendation. Do you have any objection?
No, Your Honor.
All right. Mr. Nguyen, may I place you under oath? You would have to raise your right hand.
Ông Nguyễn là bây giờ ông phải thề nha. Bây giờ anh đưa cái tay phải của anh lên.
Do you solemnly swear and affirm that your answers will be the truth to the best of your knowledge?
Anh thề là tất cả những cái câu trả lời của anh ngày hôm nay sẽ là sự thật.
Yeah.
You can put your hand down.
Lấy cái tay xuống, bỏ tay xuống.
Have you consumed any medication or alcohol recently?
Hiện tại bây giờ là anh có uống thuốc hoặc là uống rượu gì không?
Dạ, uống thuốc tới nó nôn nó trị cho ngủ. Uống thuốc để ngủ.
I just took some Tylenol
Yeah.
and some sleeping pills.
Oh, okay. Have you understood your attorney and your translator so far?
Anh có hiểu luật sư của anh và cái người thông dịch cho anh cho tới bây giờ chưa?
Dạ hiểu.
Do you
Yes, I
understand?
understand.
Do you understand that this is a criminal case against you?
Anh có biết đây là cái tội, cái hình sự, cái án hình sự đối với anh không?
Dạ hiểu.
Yes.
The two charges are misdemeanor criminal trespass at a BP gas station and obstruction of an officer by throwing coffee at him.
Hai cái tội nhẹ là một cái là anh đi tới BP và không có sự đồng ý của họ, và cái tội thứ hai là anh ném ly cà phê vô cảnh sát.
Dạ hiểu.
Yes,
If
I
you-
understand.
If you decide to willingly and voluntarily plead guilty to these charges, your sentence will be time served and you'll be released within 24 hours.
Nếu mà anh sẵn sàng nhận cái tội ngày hôm nay đó, thì cái hình phạt của anh là trong những cái thời gian mà anh đã ở trong tù, và anh sẽ được thả trong vòng 24 tiếng đồng hồ.
Dạ, cảm ơn chị.
Yes, thank you.
Have you understood your attorney so far?
Anh có hiểu luật sư của anh nói nãy giờ những cái gì không?
Dạ hiểu.
Yes,
And
I understand.
are you satisfied with his representation?
Anh có hài lòng với cái sự đại diện của luật sư của anh không?
Dạ hiểu. Dạ hiểu. Hài lòng.
Yes.
If you plead guilty to criminal trespass and obstruction, you would have to give up the following rights.
Nếu mà anh nhận tội về hai cái tội nhẹ đó là tới cây xăng mà không có sự đồng ý của họ và ném cà phê vô cảnh sát, thì anh phải bỏ tất cả những cái quyền lợi của anh như sau.
The right to go have a trial.
Quyền lợi là có quyền ra tòa.
The right to go back to court to challenge challenge the state.
Quyền lợi là có quyền ra tòa và cãi lại với tòa.
To examine witnesses.
Có thể nói chuyện với những người chứng.
And have the state try to prove the charges against you beyond a reasonable doubt.
Và có quyền bắt chính phủ phải chứng minh cái sự làm lỗi của anh, và không có gì mà tất nhiên là họ phải chứng minh thật sự tất cả.
Are you prepared to give up these rights?
Anh có bằng lòng từ bỏ những cái quyền lợi này không?
Repeat.
Anh có bằng lòng bỏ cái quyền lợi này không?
Yeah.
Yes.
Yeah.
If you enter a plea of guilty, that may have a negative impact on your residency status if it applies.
Nếu mà anh nhận tội ngày hôm nay đó là nó có thể ảnh hưởng tới cái thẻ xanh của anh đó.
Yeah, I know.
How do you plead to one count of obstruction of an officer and one count of criminal trespass?
Bây giờ anh nhận tội như thế nào về một tội là ném cà phê vô cảnh sát và một tội là tới chỗ kia không có sự đồng ý của họ?
Dạ, tôi nhận tội vô trì chị.
I plead guilty.
Your sentence is 12 months to serve 121 days, credit for time served 121 days. you are to stay away from the BP gas station at 720 Donald Lee Hollowell Parkway in Atlanta, Georgia.
Bây giờ đó là cái tội của anh là 12 tháng, nhưng mà cái số ngày của anh là 121 ngày là anh đợi trong tù rồi, thì không có phải ở thêm nữa, và anh phải không có được tới cái cây xăng BP là 720 Holloway ở Atlanta nữa nha.
Yeah.
Yes.
Mr. Nguyen, if you return to that BP gas station, do you know which one I'm talking about?
Yeah.
Nếu ông Nguyễn, nếu mà ông trở lại cái cây xăng BP á, anh có biết cái cây xăng mà tôi nói không?
They may arrest you again.
Nếu mà anh trở lại cái cây xăng đó là họ có thể bắt anh nữa nha.
Yeah.
So you cannot be in the store, you cannot be in the parking lot, you cannot be on its sidewalk.
Yeah.
Anh không có thể nào đi vô trong cái tiệm đó, anh không có thể nào ở bên ngoài, anh không có thể nào mà đi lòng vòng vào cái cây xăng đó nha.
Yeah.
Thank you.
Yes.
That concludes this case.
Thank you, Your Honor.
All right. Ms. Pham, any questions? Otherwise, you're free to go.
Thank you so much, Your Honor.
You're welcome. Thank you. All right. Mr. McLean, you have one more case in courtroom 2, Mr. Malise.
Right, I'm going to call that 2392 number now.
Okay, you still have to talk to him?
Yes.
Okay, I'm moving on then to South Annex. We have another case with Deputy Milton.
Position 3 and 4.
Okay, thank you. Mr. Finling, Mr. Jordan, we can mute courtroom 3, please.
Sorry about that, Your Honor.
No problem, no problem. Just want to make sure. All right, thank you. All right, we are addressing Shadarius Davidson. Ms. Davidson, if you could come forward to the computer, please.
Have a seat there.
All right, Ms. Davidson, you have 2 cases with us this morning. First, I'd like to remind you that you have a right to remain silent, and anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Zach Finley. The first case is 22 CR 001-711H, in which you've been accused of theft by shoplifting, obstruction of an officer, and criminal trespass and damage to property from a March 23rd, 2022 incident involving a Texaco gas station. The second case is from a March 25th, 2022 incident, and this is for misdemeanor obstruction of an officer and driving or fleeing or attempting to elude a police officer. So these are the 2 cases against you. And Mr. Finling, what is your announcement for both cases?
Yes, Your Honor. These are going to be arraigned and a bond hearing, Judge.
All right. Do you want me to read the accusations for both cases?
No, Your Honor.
All right. Ms. Davidson, with regards to both cases, that is a total of 5 misdemeanor charges. And with regards to all these charges, they are misdemeanors, and you will be represented by counsel at all phases of these cases. If you decide to plead not guilty, both cases will be scheduled for trial, during which time the prosecutor has the complete burden to prove the charges against you beyond a reasonable doubt. If the state prevails and with regards to his burden of proof and does overcome your legal presumption of innocence, you could be convicted of 1 or more of these charges, and you could face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead to both cases that I've just listed?
Not guilty.
All right. Your cases have been arraigned and further notice for trial. Anything else, Mr. Finley?
Just in regards, only regarding bond.
All right. Let me see now. With regards to position 3, she's got a bond that was set on March 26th by Judge Williams, I believe, and that was for a $2,000 split bond.
That's correct, Judge.
It is, looks like it's 1,000 good bond and 1,000 split bond, and to stay away from the Texaco gas station, no alcohol, drugs, and weapons. And with regards to position 4, it is also the same, is a $2,000 signature bond through the jail. Also stay away from, no, there's no stay away, just no drugs, alcohol. Okay, looks like we are considering a $1,000 good bond from position 3.
Yes, Your Honor. We are asking for a signature bond on behalf of Ms. Davidson, but if not inclined, then a total bond for position 3 not exceeding $500. Ms. Davidson really struggles with money in her own life. Also, she does not know any numbers, any phone numbers by heart. She's been unable to obviously access her cell phone to retrieve those numbers. So she's kind of sitting there with really kind of nowhere to turn. Obviously, this is a low bond, although low is just not looking like she's going to have an opportunity to contact someone. She did give me a friend's number that I'm trying to get in contact with to get, you know, a family member's number, so maybe they can help out Miss Davidson. But Miss Davidson's born and raised in Atlanta, so she definitely has community ties. She's extremely close with her mom, who lives here as well, and that's where she would be staying once she gets out. And
do you have the current address? I have a Jonesboro at Fieldstone. Is that the address?
Judge, I have her mom's address, which is it's on Fairburn Road.
Okay, and would you be able to put that to
just hold on. I'll be almost.
Yes, Judge.
If Miss Milton can take it, she can send it to
okay.
Pretrial as well as to Mr. Jordan at FC State Court.
Yes, Judge.
All right.
That address is.
Oh, I mean, just have it typed up in the chat.
Okay. Yes, Judge. No problem.
All right. Okay, anything else?
No, Your Honor.
Okay. And Miss Webb? Yes, ma'am.
Yes, Your Honor. Okay. I'm sorry. What was it you wanted me to do, Your Honor?
Take down her mother's address and put it in the chat to Miss Harrison and to Erica Harrison and to FC State Court.
Yes, Your Honor.
Thank you. All right, Ms. Webb, I'm sorry.
Yes, Your Honor. The state is opposed to having a signature bond for the obstruction and theft by shoplifting charge, in particular on the events that took place on March the 23rd, where an Atlanta Police Department responded to a trespass call. The facts behind the case were relatively simple. Miss Shadarius went inside of that Texaco gas station and became irate with the management after her pump timed out. The manager was explaining, I was started back, but it's timed out because you paid with a debit card. She began trashing that gas station, Your Honor, by throwing around the food stands and destroying food and drink products, including leaving the store with a Gatorade and I think a pack of noodles, Your Honor. When the officer responded to the call, she was still at the gas station at the pump. He approached her. She again began yelling and screaming at that officer. And when he told her, like, calm down, they're trying to press charges, but let's see if we can work this out. She continued to yell and scream, and at some point entered her vehicle and drove off at a high rate of speed, Your Honor. As far as the events that occurred just 2 days afterwards, after she drove off from the scene on the 23rd, the officers were able to locate that vehicle, which was a Nissan Versa, around the Metropolitan and Caslin Street in Atlanta. And upon activating their lights and to signify the defendant to pull over, instead of pulling over, Your Honor, she again took off at a high rate of speed, causing the officers to pursue her in a slight chase. They did suspend that chase, and her vehicle was also located later that evening, in which she was ultimately arrested. But the officers had to do a pit maneuver in order to disable that vehicle to apprehend the defendant, Your Honor. Considering the facts of both of these cases, Your Honor, the state is opposed to the a signature bond for the obstruction and shoplifting charges, Your Honor, and we believe that the bond shall remain the same.
Okay.
Nothing further, Your Honor.
Understood. Ms. Davidson is going to be reporting to pretrial, and the bonds in both cases are going to be amended. For the theft by shoplifting, that's going to be a $2,000 signature bond through pretrial. The obstruction is $1,000 through pretrial. The criminal trespass is a $2,000 signature bond through pretrial. So for position 3, that's going to be a $5,000 signature bond through pretrial services. The case position 4, Mr. Findling, I know you didn't ask for an amendment, but that's going to be amended to a $2,000 signature bond through pretrial services. Her total bond, yep.
Oh, I was gonna say, I apologize, that wasn't clear. I probably didn't do a good job of advocating for the signature bond. That's what I meant to do. But thank you, Judge.
All right. So for position 3 and 4, bonds are all amended to signature bond through pretrial services. That's a total of a $7,000 signature bond through pretrial services. She will report to pretrial once a month. She is to abstain from all illegal drugs and no alcoholic beverages and no weapons and no firearms. And she will be subject to random screens by pretrial services. She will stay 500 yards away. That's the length of 5 football fields from the Texaco gas station at 3330 Martin Luther King Jr. Drive in Southwest Atlanta. And she will undertake 2-week anger management classes at her expense. These anger management classes must be completed within the next 120 days of being released from jail. So pretrial will need a certificate from an anger management program that she has completed a 14-day anger management program while she's out on a pretrial bond. Deputy Milton, can we unmute South Annex, please? All right. Ms. Davidson, do you have any questions?
Yes. In reference to the charge of saying that I stole the parade or
Miss Davidson.
No, I do. Let me, no, Mr. Findling, do not comment about the facts of the case. Anything you say, the statements can and will be used against you. Okay. You're getting a signature bond so that you can help your attorney defend you in a court of law. So if you want to keep talking about the facts of your case, go right ahead, because we have prosecutors who are going to take down everything you say.
That's fine.
All right. So let me repeat again. Do you have any questions about your bond?
No.
All right. Once you're released, you need to enroll in an anger management program in which you need to complete a 2-week anger management program at your expense. That must be done within the next 120 days. Do you understand?
At this point, I've lost my job, so I can't afford an anger management program.
Ms. Davidson.
Well, in that case, I can just then keep your same bond and then you can stay in jail until you make bond. What would you like to do?
It really doesn't matter at this point.
All right, Mr. Findling, apparently she doesn't want an amended bond, so I don't have to give her a signature bond.
Ms. Davidson, court, what we wanted to happen has happened in court today with getting a signature bond. So if you could, I will speak with you soon, but if we could proceed.
All right, Mr. Findling, Mr. Jordan, please place Mr. Findling and South Annex in a breakout room. And Mr. Findling, maybe you might want to talk about anger management and conduct in court, especially how she addresses court.
Understood, Your Honor, I will.
All right. Ms. Duncan, please place Mr. Findling and Ms. Davidson in a breakout room. All right. Do I have Mr. McLean? Are you ready to address Mr. Malise? Mr. McLean?
Let me jump back into the main meeting, Your Honor. I was speaking with him by phone. Now that he is competent, Your Honor, I believe he does have the ability to understand the proceedings, and he does have the ability to do what he wishes, which is to enter a guilty plea, and he wishes to accept the state's offer as a negotiated plea. I did question whether or not funds were available. The expensive part of the recommendation from the state is that SDETs, the SDE, the evaluation frequently costs about $1,500. And a lot of my clients are unable to make it. He believes his relatives will help him do so.
Okay.
Given that and given his competency, I'm not going to stand in the way, certainly, of his accepting the negotiated plea if he wishes to, which I
All
believe
right.
he does.
Okay. So courtroom 2, do we have Mr. Malise available? Courtroom 2? All right.
Hold on one moment for me, Judge, please. I apologize.
It's gonna be a negotiated deal or non-negotiated?
Thank you.
All right. So we are returning to Amit Malisk, 22 CR 000096Y. Mr. Malise, are you aware of the charges brought against you?
I am.
All right. You have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and Mr. McLean will be representing you. This is going to be a plea hearing in which the state is going to articulate its recommendation, and then I will hear from your attorney, after which, if you still want to proceed with entering a guilty plea to the charges, then we will place you under oath. Ms. Duncan, what is the recommendation without referencing the charges?
It's the recommendation is a global recommendation for both charges, Your Honor. The state recommends 12 months to serve, 180 days. Credit for time served, 91 days, with the balance probated, a stay away from Tiffany Rivera and the Woodruff Park, as well as an SDET. Yes.
All right. Thank you. All right. And Mr. McLean, I've already heard your preamble with regards to the cost of the evaluation program. This is something that if your client is willing to undertake, I will be waiving probation fees. So shall I proceed with the plea?
Yes, Your Honor. I believe that would be appropriate. I do comment as counsel that given the language of each accusation, I can't see how it would not merge.
Ms. Duncan, is the state willing to merge the simple battery into count 2?
Give me one moment to verify.
That's fine, Your Honor. The simple battery can merge into count 2.
All right. So we are only addressing one count, count 2. And I'm going to waive sounding on that. Okay. Mr. McLean, then shall we proceed?
Yes, Your Honor.
Do you stipulate to factual basis, venue, and ID for count 2?
We do.
All right. Mr. Malise, for purposes of this plea hearing, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
Thank you. Mr. Malise, you can put your hand down. Have you consumed any medication or alcohol recently?
No, Your Honor.
Have you understood your attorney?
Yes, Your Honor.
And are you satisfied with the services?
I am, yes, Your Honor.
If you decide to plead guilty to the charge brought against you, is anyone forcing you to take this plea?
No, Your Honor.
And if you do decide to take this plea, you will have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury, to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And taking this plea may have an adverse impact upon your residency, if that applies. Do you understand, sir?
Yes, Your Honor.
Are you entering this plea willingly, knowingly, and voluntarily?
Yes, Your Honor.
How do you plead to count 2?
Guilty.
Your sentence is 12 months to serve 180 days, credit for time served 91 days. The remainder of your time, you'll be on probation. You have to report to your probation office no later than by next Thursday. Do you understand?
Yes, Your Honor.
And you will report to 132 Mitchell Street, which is the probation office. You will give them your current address, your phone number, and an email address.
Yes, Your Honor.
Your probation fees will be waived. You will report to probation every month, and you must complete an SDET program, and you must begin that program within 3 months of being released.
Yes, Your Honor.
All right. At all times, you have to stay 200 yards away from Woodruff Park, and you can have no contact with Tiffany Rivera. Understood?
Yes, Your Honor.
That concludes this case.
Will
Thank
I
you.
be released today, Your Honor?
You'll be released within 24 hours and report to probation by next Thursday.
Yes, Your Honor.
If you don't report, we will issue a probation warrant and have you back in jail and serve out the rest of the 6 months in prison.
Yes, Your Honor.
Okay, thank you. All right, I believe that concludes our SAP calendar. And then I have my 11 o'clock calendar. Yes.
Judge Law, we just have position 1.
Oh, I'm sorry. I'm sorry about that. Mr. Bovell, what was was he still going to arraign his case?
So we were actually going to be a non-negotiated plea, Judge.
Oh, okay. All right. So we are returning back to position 1, Fadli Bovell, 22 CR 001-860Y. Mr. Bovell was accused of criminal trespass from February 15, 2022. And with regards to this case, Mr. Bovell, you've been advised of your right to remain silent. Your attorney is Mr. Findling. So is this going to be a non-negotiated plea?
That's correct, Judge.
All right. So Ms. Webb, what is the recommendation for Mr. Bovell?
Yes, Your Honor, the state is recommending 12 months to serve 52 days, credit for time served 52 days, balance probated, a theft reduction course, restitution to the victim for $267.50, and 20 hours of community service, Your Honor. Nothing further.
Thank you. Ms. Harrison, this is position number 1. Does he have any other open cases or probation matters?
One moment, Judge, let me check. No additional open cases.
All right, thank you. And how many cycles does he have?
He has 15.
Okay, thank you. All right, Mr. Findling, what's your recommendation for your client?
Yes, Your Honor. And also, I just want to let the court know his last name actually starts with an R as in Robert. I don't know. I just wanted to.
So what's the correct spelling of his name?
It's a R as in Robert, OBALE. So everything else is correct. Just the first letter is supposed to be an R.
All right. So he'll also be known as Fadli Robel. Is that correct?
That's correct, Judge.
All right. And your client's recommendation or?
Yes, Judge. Mr. Rabali is looking forward to getting out of court or getting out of jail. It is Ramadan, so looking forward to that. He has been in Georgia since 2015. He's only been arrested since then once that I was able to see, and it was a possession of marijuana less than an ounce that was dropped. So he has been walking a straight line for a while. He's very involved in the African community in Atlanta and finds odd jobs through the community to make some money, but money is an ongoing issue in his life. So He agreed, obviously, to the restitution. I said that was going to be a must. He said, really have to work hard to find jobs to pay that off. But we are asking for the theft reduction course to be removed, Judge. And also that once he does complete or pay the restitution and the 20 hours community service, if his balance could be suspended or become not reporting.
What's the objection from the state with regards to removing the theft reduction program? And did you say the 20 hours of community service?
No, we are not opposing the 20 hours community service, only the theft reduction course, Judge.
Oh, okay. And for probation to be non-reporting once he completes.
That's correct, Judge.
Okay. Ms. Webb, what's the objection?
Yes,
But
Your
this is
Honor.
a criminal trespass, right? Not a theft case.
Yes, Your Honor, it's a theft case. In this particular case, the defendant busted a vehicle window at a lot on 1 Margaret Mitchell Street, Your Honor. In that particular case, a witness was actually able to flag down a patrolling Atlanta police officer who saw the defendant, or allegedly saw the defendant, take a brick and bust through the front window, Your Honor. We did make contact with the victim. He said that vehicle actually wasn't his personal vehicle, but a company vehicle, Your Honor, and there was severe windshield damage that the company had to cover for. I understand. I'm getting feedback.
I know someone is talking. I'm so sorry. Folks, if you're not part of this case, please mute your screen. Thank you. All right. Sorry about that, Ms. Webb.
Yes, Your Honor. And in regards to the time that Mr. Robale has been in Atlanta, I understand that PD Filling said it's been 2015, but Your Honor, the defendant actually has a large history out of Washington for theft cases, Your Honor, that includes an open robbery case from King County, Washington, open theft of motor vehicles from 2021, open robbery case out of Seattle from 2020, and an open shoplifting case that I have from Atlanta in 2021. He also has convictions for criminal trespass in Seattle 2015. He has an FTA from 2021 from, I'll spell the county name is TUIKWILA out of Washington, larceny from 2021 out of Washington, and a malicious mischief felony from 2021 out of King County, Washington, Your Honor. For those reasons, we do believe a theft course is indeed viable here, especially considering the facts surrounding this case, where he allegedly took a brick and bust a car vehicle window and took items out of that vehicle, Your Honor. So although it was charged as a criminal trespass, the allegations surrounding the facts of this case, Your Honor, does support a theft reduction. And considering the defendant's extensive theft history, Your Honor, the state is wholly opposed to modifying the plea recommendation without that theft reduction course, Your Honor.
All right. Okay, Mr. Robel and Mr. Findling, I will remove the theft reduction class since despite his history, this is clearly just an element of damage to property. But in lieu of removing the theft reduction class, it will be 40 hours of voluntary community service, and he will report to probation every month. It will not be non-reporting. It will be no drugs, no alcohol, no weapons, no firearms. He is to pay restitution. Restitution must be paid within 4 months while he's on, well, I guess, yeah, he has to pay restitution within 4 months of being on probation. And then after 4 months, I will waive his probation fees for 6 months. So give him a couple of months off, and then he'll need to start paying probation fees after 6 months. So April, May, June, July, August, September, he will start paying probation fees from October 1st, 2022 onwards. All right, so Mr. Robel, you have an opportunity to take this plea, or we can clearly, you can enter a plea of not guilty and we can schedule the case for trial. What would you like to do? I can't hear you, sir.
I'll take that, please.
All right. Mr. Findling, are you satisfied that your client would like to proceed?
I am, Judge. And
All right.
also I'd like to just thank the ASG for pointing out the criminal history. I was just going off of obviously what I see on Odyssey.
Understood.
Yeah.
Okay, thank you. Mr. Findling, do you stipulate to venue and ID?
I do.
All right. Mr. Bobel, also known as Mr. Robel. First of all, I need to place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Okay. Have you consumed any kind of medication or alcohol recently?
No.
And have you understood the proceedings so far?
Yes.
And are you satisfied with the services of your attorney?
Yes.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to go back to court, to have a trial before the judge or a jury, to confront your accuser, examine witnesses, have the assistance of counsel to challenge the state's case or present your own defenses, as well as to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Is anyone forcing you or inducing you to take a plea today?
No.
And if you take a plea today, it may have an adverse impact upon your residency if that applies. Do you understand, sir?
Yes.
How do you plead to one count of criminal trespass causing damage to property?
Guilty.
Your sentence is 12 months to serve 52 days, credit for time served 52 days. The balance will be on probation. You have to report to the probation office by next Wednesday, no later than 5 p.m. at 132 Mitchell Street. Do you understand, sir?
Yes.
Excuse me, not next Wednesday, next Tuesday, next Tuesday.
So I'll do that every week, so once a month, right? Every month?
You start by going there next Tuesday, and then you'll report every month, and they will give you a date to which you must report.
Yes, Your Honor.
Your probation fees shall be waived for the first 6 months up to September of 2022. You must pay off the restitution of $267.50 within the next 4 months while you're on probation. While you're on probation, you will also complete 40 hours of voluntary community service. That's 40. You can complete the nonprofit services at any nonprofit agency except a school and except a religious institution. Do you understand?
Yes, Your Honor.
All right. Your probation will be reporting every month, and you will start paying probation fees from October 1st, 2022. You shall remain in the state of Georgia, and you cannot leave the state of Georgia unless you get a court order. So you will be in Georgia at all times. Do you understand, sir?
I will start paying on October 1st.
You will start paying probation fees from October 1st. You must pay off your restitution within the next 4 months.
All right.
You must pay off the $267 by the end of August 2022. Any questions?
No.
All right, thank you. Mr. Findling, going back to your case with Ms. Davidson, position 3 and 4. Mr. Milton?
Yes, Your Honor, we're here.
All right. I'm sorry, did Mr. Robel have a question?
All right, so will I be released from jail today?
Within 24 hours.
All right.
Thank you.
Judge, that's all I have in courtroom 2.
Yes, thank you. Thank you, Deputy. I appreciate you. Thank you. Okay. Deputy Milton?
Yes, Your Honor.
Okay. With regards to Ms. Davidson and so Mr. Findling, does she understand the terms of this pretrial, or
Yes, Your Honor.
shall we stay with the surety bond?
No, Your Honor. We would like to stick with the signature bond, and I did discuss with Ms. Davidson, obviously, how to behave in court.
All right, thank you. All right, Ms. Davidson, you must report to pretrial once a month, and please remember that you need to complete your anger management classes within the next 120 days. You understand?
Yes.
All right. That this case is a further notice for trial, and please send the amended orders for the signature bond to our litigation manager. Thank you.
Will do. Thank you.
All right, Deputy Milton, did we have another case?
That's it, Your Honor. We'll finish here the sub annex.
All right, thank you. You have a good day. Thank you.
Thank you. Thanks,
All right.
everybody.
Thank you.
We're going to, we have counsel, Mr. Stephen Weiner here as well. Do we have a case on the 11 o'clock calendar?
We do, Judge. Sherry Bain, and she's on, and I think Miss Weidman's on also, and we worked out a plea.
Judge, I'm actually going to take that plea. This is Andrea Allaby for the state. Good morning.
All right, thank you. All right, from our competency calendar for 11 o'clock. Are you here for the 11 o'clock? All right, please hold. Thank you. I'm sorry, Mr. Weiner, what position number was that? Or what was the client's name?
Sherry Bain, Judge. I don't know the position.
Judge, it's position 1 on the add-on, the non-jail plea calendar.
I don't think we got that printed up. So just, no, I don't need it. No, I'm just going to pull that. Give me a second, please. We are addressing Sherry DeCozen Bain, B-A-I-N, case number 22 CR 001-765F. Ms. Bain, I do see you present, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Stephen Weiner will be representing you. This is going to be I'm sorry, did you say non-negotiated plea?
It's a negotiated plea, Your Honor.
Negotiated plea, all right?
Yes.
So Ms. Bain, for purposes of the plea, may I place you under oath? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. All right, Ms. Allaby, could you tell me what is the state's recommendation for the defendant?
Yes, Your Honor. Prior to the plea, the defendant did complete 40 hours of community service. We did request 10 hours, a drug and alcohol evaluation, victim impact panel through Mothers Against Drunk Driving did provide proof to the state. We have reduced the DUI to reckless driving. The recommendation as to count 1 will be 12 months probation, the reckless driving, $1,000 fine, 100 hours of community service, to take and complete a risk reduction course. Count 2, the open container, is a $200 fine. Count 3, the failure to maintain lane merges with count 1.
Okay. And so with regards to this one, it's the only thing that's left to be completed is the $1,000 fine, the 100 hours community service, and risk reduction, correct?
That is correct, Your Honor. The $200 fine.
Oh, and for the open container, yes. And she
Judge,
has, I'm sorry, Mr. Weiner, yes.
I'm sorry, Judge. The risk reduction is done. She's done, as I said, 40 hours of the community service, alcohol and drug evaluation, and the MAD panel. So she's got to pay the fines and the additional community service.
All right.
And if there's any recommended treatment from the drug and alcohol evaluation, to continue with any treatment.
And there was not. So.
Okay. All right. And Mr. Weiner, do you stipulate to the factual basis, venue, and ID for reckless driving and open container?
Yes, Your Honor, we do.
Ms. Bain, have you consumed any kind of medication or alcoholic beverages recently?
No, ma'am.
All right. And are you satisfied with the representation of your counsel?
Yes, I am.
And have anyone induced you to take a plea today or forced you to take a plea today?
No.
And have you understood the proceedings so far?
Yes, ma'am.
Ms. Bain, if you decide to plead guilty to reckless driving in an open container, you would have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury with regards to the original charges, to be able to have the assistance of counsel to challenge the state's case, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And by pleading guilty to these charges, they may have an impact upon your residency status if it's applicable. Are you still willing to proceed with the plea?
Yes, ma'am.
How do you plead? To 1 count of reckless driving and 1 count of open container.
Guilty.
The charge of failure to maintain lane will merge with reckless driving. Your sentence is 12 months to, I believe it was to serve 24 hours, credit for 24 hours. Is that correct? Someone?
Can you repeat that, Your Honor?
12 months to serve 24 hours.
There was no requirement of confinement.
Okay, so it was 12 months all probation. For the reckless driving, it's $1,000 fine, 100 hours of community service, of which you have 60 hours left. Complete the risk reduction, which I believe you have completed. Complete the alcohol and drug evaluation and treatment, which I believe you've completed. Attend 1 victim impact panel through MAD, and I believe you've completed that. So the thing that's left is the fine and 60 hours of community service left. On the open container, the only item that remains is the $200 fine, which is left to be completed. Anything else?
Your Honor, I would ask, upon completion of the final requirements, may probation terminate? There's no reason to keep her on like a DUI.
Okay.
That is not the agreement that we made with regard to this case. We are asking that defendants remain on probation for the entire 12 months.
I will make it non-reporting.
That's fine, Judge. That's
All right.
fine.
So she will report to probation by next Tuesday at 132 Mitchell Street to make sure that she completes the remaining items of her sentence. And then once completed, and Mr. Weiner, please be sure that Ms. Bain has all the necessary documentation to show completion of the items so indicated.
Yes, ma'am.
All right, thank you. And Ms. Bain, once you have completed the remaining items, your probation will be non-reporting, which means that you don't have to report after the completion of the conditions, but you will still be considered on probation. So no alcohol and no infractions with the law.
Yes, ma'am.
All right. Anything else, Mr. Weiner?
That is it, Judge.
All right, thank you. Thank you, Ms.
Good to
Allaby.
see you.
You too. Ms. Bain, who has the documentation for the plea?
I have it right here, Judge.
Oh, we have it?
Yeah.
Okay. All right, that concludes this matter then. Thank you.
Thank you, Judge.
Thank you, sir. All right, we had one other plea matter on that calendar. And that is Pierre Montanus. Is Pierre Montanus present?
Yes.
All right.
Yes.
All right. Let's go ahead and correct his Zoom panel name to Pierre Montanus.
Montanez.
Montanus, excuse me.
Yes.
All right. And Mr. Montanus, who is your attorney?
Melvin Ash.
I'm online, Your Honor.
Okay.
All right. Thank you. Give me, sorry, 1 second, please. Just get through this paperwork. There we go. Put this. All right. Thank you. All right. Mr. Montanez, this is case 22 CR 001763E, in which the state has accused Mr. Montanez of reckless driving and impeding traffic flow. You have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and Mr. Melvin Nash will be representing you. Is this a negotiated plea, Mr. Nash?
It is, Your Honor.
All right. Mr. Montanez, could you please raise your right hand so I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, thank you. Ms. Allaby, are you addressing this plea as well?
Your Honor, it'll be Jamila Wyman on behalf of the
Ms.
state.
Weideman. Okay, thank you.
Good morning.
Good morning. All right, Ms. Weideman, what is the proposed recommendation from the state?
Your Honor, prior to the plea, Mr. Montanus did complete a MAD victim impact panel, 10 hours of community service, as well as a drug and alcohol evaluation. Our recommendation for the plea today, Your Honor, for the reckless driving is 12 months probation, 100 hours of community service, $1,000 fine, a risk reduction course, and to complete any treatment recommended. And it was part of our recommendation, Your Honor, that the impeding the flow of traffic would merge into the reckless driving.
So it's 12 months probation, $1,000 fine, which is still to be completed, a risk reduction program, the one victim impact panel, which is done. He's completed 10 hours of the 100 hours of community service, which leaves him with 90 hours left. And an alcohol and drug evaluation treatment, which I understand has been completed. Is treatment been recommended?
Your Honor, I'm sorry, I have had an opportunity to read the evaluation and there was no treatment recommended.
Okay, so he's completed that. And the impeding traffic flow charge will merge. So the only issue is reckless driving. All right, Mr. Nash?
Your Honor, that's correct. Mr. Montanus is, where are you living at now, Mr. Montanus?
Chicago, Illinois.
Yes, so Your Honor, he would be needing to report through mail or telephone reporting.
All right, I will allow virtual or phone in or mail in reporting depending on what JCS would require. Probation, Mr. Montanus still has items to complete on his sentence. Would you be able to reach him through email or virtual?
Yes, ma'am. Yes, Your Honor, we do mail-in reporting.
All right. Mr. Nash, on your Zoom, there is a chat feature.
Right.
And if you can pull down the JCS probation as a participant, you can send Mr. Montanus' current address, phone number, and email to JCS. Mr. Montanus can do that as well on his Zoom. And you just make sure you send it to JCS.
You know how to do that, Mr. Montanus?
No, my wife had to set up everything.
Okay, so I will send them your phone number and your email address before I get offline. And then they'll be in contact with you. Your Honor,
right.
also.
So JCS, if you can send a hello chat to Mr. Nash.
Mr. Nash?
Yeah. Look at your chat feature. Just click on chat.
All right.
And you should see a response from JCS probation. Do you see it, sir?
I do, Your Honor.
All right. Just have to type in his address, phone number, and email.
Okay. I will do that.
All right. And do you stipulate to the factual basis, venue, and ID for reckless driving, Mr. Nash?
We do, Your Honor.
All right. Okay. Mr. Montanus, with respect to this possible plea, have you consumed any kind of medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with the representation of your attorney?
Yes, Your Honor.
And is anyone forcing you or inducing you to take a plea today?
No, Your Honor.
All right. Mr. Montanus, if you decide to plead guilty to reckless driving, you understand you still have some items on probation you need to complete, and you'll be reporting to probation through Zoom or mail-in order to make sure it's all completed. Do you understand, sir?
Yes, Your Honor.
All right. And if you also decide to take this plea, you will have to give up your constitutional rights to go back to court to have a trial before a judge or a jury on the original charges that were brought against you, to be able to have the assistance of counsel to challenge the state's evidence, confront your accuser, examine witnesses, present your defenses, as well as have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Waive the rights, yes.
All right. If taking this plea may have an impact upon your residency status, if it does apply, are you still prepared to go forward with the plea?
Yes, Your Honor.
And how do you plead to one count of reckless driving?
Guilty, Your Honor.
Your sentence is 12 months probation, during which time you will be reporting to probation either by phone, email, or virtually, or mail-in reporting. You would have to pay off a $1,000 fine plus all fees and costs. Complete a risk reduction program and you can, if you have not done so, we can accept a program that is acceptable to Fulton County probation. Do you understand?
Yes, Your Honor.
All right. You have completed your victim impact panel. You still have 90 hours of the 100 hours of voluntary community service to complete. You may do so at any nonprofit agency in Chicago as long as it's not a school and not a religious institution.
Yes, Your Honor.
You will, I believe you've already completed the alcohol and drug evaluation. So that leaves only the community service, the risk reduction, and the fine.
Your Honor,
Okay.
may he be
Mr.
terminated
Nash?
once he completes that?
Ms. Weideman?
Your Honor, the state would object to that. That was not part of the agreed upon recommendation. We would ask that he remain on probation.
He can remain on probation, but once he completes the remaining elements, it will be non-reporting.
Thank you, Your Honor.
All right. All right, Mr. Montanus, do you have any questions about your sentence?
No, ma'am.
All right.
Yeah.
Okay, thank you.
Thank you, Your Honor. That completes my business. May I be excused?
Yes, sir. Thank you.
Yes, thank you, Your Honor.
Okay, thank you.
See you, Mr.
All
Moore.
right. I am got a competency calendar and I have a young lady. Yes, ma'am. Please speak up.
I'm married to and our house is 2598 Family Road, Alaska, Georgia, 03540, 66 Gaborone.
All right. Is he on our calendar this morning? Curtis Jackson?
It's they say my name, baby.
Let me ask you one question. Do you have his case number?
Oh, yeah.
Okay, I'm going to address you as soon as I'm done with my cases on computer, okay? All right. And when are they supposed to appear in court? Okay, I can address it once I'm done with these cases. Thank you. All right.
Your Honor, will you be needing me for the competency calendar? This is the court reporter speaking.
No, I'm good actually. Thank you.
Thank you, Judge. Have a great day.
All right, thank you. Mr. Walker, and who
Yes,
is
ma'am.
going to be, is it Miss Burgess? Okay, Miss Burgess, good morning. And who else is going to be in the breakout for the competency calendar? Mr. Howard? He was walking around. Mr. Montanus, Mr. Jordan, we can remove Pierre Montanus from the Zoom. He didn't realize he has to close out the Zoom panel. You can end the meeting.
Okay, I'm trying to figure out how to do this because my wife set it up. And
No problem. We can have you
Yes.
removed as well. Mr. Jordan.
Okay.
Yeah, Mr. Jordan, if we can have. Okay. Who is joining me from the public defender's office for
I
the
just text
competency?
Mr. Howard, Your Honor.
Okay, we'll.
I just text
Okay.
him.
All right.
Yeah.
So as soon as, oh, I see Mr. Howard there. Okay. For the competency calendar,
Yes.
can we just
Yes,
give me
Judge.
a 2-minute pause so I can go over the cases from the morning calendar? And I can
Absolutely,
release-
Judge.
So I can release the folks who don't need to be here.
Okay.
Okay, on my add-on state all-purpose, Cornelius Lovett, that was a plea. On the add-on plea calendar at 11 o'clock, both were pleas for Mr. Montanez and Ms. Bain, okay?
Yeah, I can hear you.
All right, and then the main state all-purpose calendar at 9 o'clock. Position 1 was arraigned and, no, that was a plea, wasn't it? That was a plea. Yeah, so position 1 was a plea. Robel, also known as Bobel. Position 2 was a plea. Position 3 and 4 were arraigned and further notice and bond was amended to pre-trial services. Position 5 and 6 were pleas. Position 7 was arraigned and further notice. 8 arraigned and further notice. 9 Jackson was a plea. 10 Lovelace was arraigned and further notice. 11 was arraigned and further notice. 12 and 13 were pleas. 14 was a plea. 15 Trappenberg was arraigned and further notice. 16 Craig Washington. What's the announcement, Mr. McLean?
Well, he had mental health issues. We could not proceed further.
So are we going to reset him to a competency calendar? Or
Probably, Your Honor. I'll consult with Mr. Howard on that. They'll take care of it. I was just helping out.
If we're going to resit him, an order would need to be entered, Your Honor.
all right. Mr. McLean will need an evaluation order for competency. Okay,
Right.
and I think
Mr. Howard's upstairs with the right forms and all. As soon as I
Okay.
finish with this plea statement that I'm going to sign with the commission or whoever we had this morning.
All right.
I'll run it.
So on position 16, Craig Washington, we will reset him to the last SAP calendar for this month. And that's going to be, what date? Is it the 28th? If you all need to move him from the 28th, just contact the clerk's office and we will remove him from the 28th if it's pending evaluation. So Mr. McLean and Mr. Howard will get together with regard to submitting the necessary paperwork for an order. And that would apply to position 16, position 17, and position 18, okay? Reset to 428 at 11 o'clock competency calendar. Oh, and position 19 as well, excuse me, all right. I think that was it for the SAP calendar then. Okay. Okay, Mr. Finling, I think that concludes. Do you need, you're more than welcome to stick around. Anyone who is not involved with 11 o'clock, you're free to go unless you just love to participate. So you're more than welcome to do so.
I'm going to jump off and do this paperwork, but thank you, Judge. Have a
All
good
right.
day.
Mr. Jordan, if you could place me and Mr. Ian Walker, Mr. Derek Howard, and Kia Burgess. Anybody else wants to be in the breakout?
That's it, Judge. Close
No,
the sign.
Yolanda Glenn, she's also a new social worker, so
Okay.
Yolanda Glenn. If
Yeah,
you
she
can.
can
All
come.
right. And Miss Yolanda Glenn too, thank you.